Okay. Welcome. How are you doing? How are the rest of you doing? You sure? I bet I know why. When I was walking in here, I found a roll of 25,000 dinars with a rubber band around them. Did anybody lose that? What's your name, sir? Doug, you're in luck because I found your rubber band. I'm an attorney. What do you expect, right? If I see money, I'm going to take it. My name's Clint Coons. I'm an attorney with Anderson Business Advisors and Law Group. Some of you may have been on a call that I was on about, I don't know, was it 6 weeks ago now, maybe 8 weeks ago now on people's dinar. That's how you may have heard about us. I put together a companion to that call on currency investing for the dinar that was also submitted up to that website, and I know many people have downloaded it, and it spurred a lot of questions. But I also want to introduce who else is here with us before I get into the firm. In the back on the right-hand side, my right, is Greg Boots in the blue suit. He's also with Anderson, one of the partners. Okay. And we have Bob Wilkinson over there in the gray suit, the red shirt. Okay. Well, that's understandable. I'll tell you a story about Bob since he wants to start it this way. Bob decided to go on a vacation not too long ago to Costa Rica. Has anybody been to Costa Rica before? Okay, I'm sure some of you plan to go there after the RV. It's a nice place, and there's a lot to do there. And Bob was there, and he decided to go fishing for what we call tarpon fish, which is a trophy fish. It fights really hard. And as he told it to me, the story, he went out on this river, and he was out there fishing. Nobody was around. He said it was very peaceful, very serene. Clint, he goes, I would recommend it to anybody to go on this fishing adventure. Well, Bob's out there fishing, and all of a sudden he hears this, psst, psst, hey, mister. Now, Bob looks around, and he doesn't see anybody. He looks up and down the river, nobody out on the river. He goes, where's this coming from? So he continues fishing. All of a sudden he hears, psst, psst, down here, mister. And he looks down. It's a big old frog. So Bob reaches down, and he picks up this frog, and he looks at the frog, and the frog looks at Bob. And he says, mister, you give me just one kiss, and I'll turn into the most beautiful woman you can imagine, and I'll make mad, passionate love to you for the rest of your life. Bob took a look at that frog, stuck it in his pocket, and he went back to fishing. Well, he's a fishing, and that frog's jumping around in his pocket and going crazy, and Bob's getting irritated because the frog keeps going, mister, mister, mister. And so finally Bob reaches into his pocket, and he pulls that frog back out. And the frog looks him in the eye and says, mister, didn't you hear me? Just one kiss, and I'm going to turn this beautiful woman, make mad, passionate love to you for the rest of your life. Bob said, I heard you the first time, frog. But at my age, I'd rather have me a talking frog. And he put him right back into his pocket and continued fishing. I'm a lawyer, okay? You don't want to challenge me, Bob. All right. Well, I want to thank you for coming here. I hope that we're going to exceed your expectations on this class. One of the reasons why we decided to put it on is that I know Dan at People's Dinar said I'll be speaking in San Francisco, and a lot of people are shooting us questions. Hey, when is this going to take place? Well, I don't know. Okay, of course it's going to be after the RV. I don't know where it's going to be. That is handled by Dan and his group. I'm just one of the speakers that he asked to come and present at that event. And quite frankly, as far as I understand, it's going to be a very short presentation, maybe 2.5 hours, 3 hours at the most. And so Greg and I were sitting around talking, and we said, wouldn't it be great if we could go out now and give people this information? Because there are a lot of unanswered questions. And we know because our inboxes are filled every day with emails from individuals asking me questions. Or, as happened on Wednesday, I got several emails from somebody, from different people actually, explaining that the new Treasury regulations that were just released, and they saw this on a website, and they throw this information at us and ask if we can verify it. And I thought, we need to put something on. We need to get this information out to people. So this is the first of many of these events we're probably going to be doing around the country to various investment groups or investors in the dinar to explain how it works. Because there's a lot of misinformation that we've discovered. I didn't realize it at first when we first started working with individual investors, because I'll tell you how this all came about. I was not invested. I was asked by Dan and another individual to come speak or come on a phone call with him. He goes, we'll have a couple hundred people on a call. Why don't you come on and talk about asset protection? Now, that's what we do. Our firm specializes in asset protection, and we work with people who invest in the stock market. We work with medical professionals. I work with a lot with real estate investors. And I said, all right, that sounds great. When do you want me to be on the call? He said, be ready in 3 days at this time. I said, all right, no problem. So 3 days at this time, which was 5 minutes before that call, Dan calls me up. He says, hey, you ready to go? I said, absolutely. So who are we talking to here? He goes, the dinar. Have you heard about it? I said, just did. What do you want to tell me about it? He goes, oh, you'll figure it out as we go along. We'll ask you some questions. I said, oh, this is not how I like to do things, because typically an attorney's not going to ask a question he doesn't already know the answer to. So I said, great. We went on that call, and I gave everybody a general overview of asset protection. And then after that call, I went and I did some studying on it. In fact, I went and did some investing in it as well. And we bought a couple $1 million. I think we are up to $5 million now we ourselves own. And I see it as an opportunity. But I also see there as potential for paying too much in tax, potential for being exposed to creditors, potential being exposed to just jealous attorneys who need nothing more than to make a buck off somebody who has money, which there's far too much of that out there in this world. As a law firm who specializes in asset protection, I can tell you I do not get along with most attorneys that I know. And it stems from the standpoint that, my grandfather was an attorney and he adopted the same philosophy that, I've never lost a case, he told me. My clients lost a few, but I never lost a single case. And they look at it as somehow they detached from what it is they're doing. They'll bring a claim against somebody and they'll say, it's not me, it's my clients who's bringing this claim. And I take, umbrage with that, and I feel that we need to balance out the scales, and the way to do that is through sound planning to ensure that if somebody was going to come after you, if they felt like you were an attractive target, that there's nothing for them to get at the end of the day. So I'll weave some stories into my own personal experiences when it comes to actual legal representation of people and individuals when it comes to asset protection. But for the most part, our firm does not handle any litigation. A lot of times people will call us up and say, Clint, I want you to represent me. I have two answers for him. I only represent two people in this world. One's my father, because he sent me to law school, so I'm on permanent retainer for life, he's informed me, because he paid for it. And the other one is my mother-in-law, because as my wife tells me, I married her, and that was a package deal. So those are the only two people I represent. We made this choice as a firm about 6 years ago. We tried both sides, and we found that to be successful and to be really good at what it is that you do, you cannot spread yourself too thin. You cannot spread yourself over different areas of the law. So we only focus on really asset protection, estate planning, and tax. Okay, so let me tell you a little bit about our firm, where we're located, and what we have to offer. Well, our practice is comprised of both attorneys and CPAs. We think that's a great mix because one of the areas or one of the problems that we ran into when we first started practicing was that we would go out there and tell people, hey, you should set this entity up for asset protection. And then they'd ask me, well, who's going to do my taxes? Well, your local CPA should understand this, shouldn't have a problem with it. So they would go down to their local CPA at the end of the year, and he wouldn't understand what we did for him. And in many instances, he would mess up or file the wrong tax return for the client based upon the structure that we've created. And we saw this as a real problem. And so about 5 or 6 years ago, we made a decision that we were going to bring a tax department in-house and find CPAs that understood what it is that we do or were open to it. If need be, we would train them on our strategies and then give people another outlet as far as whom they can work with when it comes to taxation. So it's worked well for our firm to have both. We have both the tax and the legal side. We have two offices. Our offices are in, where is that up there? We have offices in Washington State and Tacoma, and we also have offices in Las Vegas, Nevada. People ask me, well, why are you in Las Vegas and Washington State? Well, initially when we started out back in 97, 98, when Greg and I started practicing, we came out of the gates roaring. Within a year and a half, we had a staff of over 55 people working for us. I had a lot of attorneys working for me. And I found that it was just way too expensive to run my business in the state of Washington because they taxed me out of that state. Washington takes the approach, hey, even if you lose money, you still have to pay tax just for the privilege of doing business here. And then not only is it the state that I had to pay tax to, the city would then come to me and say, oh, you lost money, doesn't matter, the privilege of having an office here, you have to pay us some tax. And so eventually we looked at this and said, this is too expensive. We're going to shift the majority of our operations down to Las Vegas. We bought a business down there, and then we moved a lot of our employees down there. And so you found a complete flip-flop. We used to have 6 people down there, and now we got 6 to 8 in Tacoma. We have over 35, 40 people down in our Las Vegas office because it's less expensive to run our business out of Las Vegas. Not to mention that if any of you have listened to that telephone call that I did with Dan, or if you read my report, I recommend that you create a Nevada limited liability company for asset protection. That goes hand in hand with what we do. To have a presence down there is extremely important. We have a lobbyist that works for us exclusively to maintain the laws in Nevada. We pay him on an annual basis. Well, they go into session every 2 years, but to ensure that things do not change, because we do not want uncertainty in the law. That's the worst thing you can have. You create uncertainty. I mean, we have it in the tax code right now. What's tax rate going to be in 3 years, Nick? Don't know, do you? Nobody knows, right? Because what we have right now is every 2 years, we go and enact a temporary tax code. And so what does that do to the small businessman? He's going out there, he's trying to figure out how much money he's going to make and how to plan for that 2 years down the road, 3 years down the road. You cannot plan if everything is based on who is going to be elected to Congress and whatever they decide to do that year. That's not the type of environment that fosters business. Actually, it discourages businesses from being created. So we look for jurisdictions that are stable in their laws, and we work to maintain that stability. So that's what we do down in our Las Vegas office. We support the Nevada entities that we create. We give them a physical presence down there, but we bring all this together, the asset protection on the tax side, out of our Las Vegas office. All right, let's go on here. So what I want to do is I want to start off with a pop quiz, because these are questions that you're going to see up here that we've been writing down that we've received over the last several months from individual investors. And so the first one, I can protect my dinar with a grantor trust. Anybody venture to guess? Is that true or false? If you don't answer, I will just call on you. Greg, true or false? False. You say, why do you say false? I like it. We got a mathematician and a jokester in here. Okay. So, Greg, whatever work we do for you, it's double. Eric, would you like to take a guess on this? False? Why? It just doesn't sound right, does it? Maybe it's the way I'm asking the question. It makes it seem like it's false. Well, has anybody been on a call where somebody has promoted the use of trust in asset protection planning and told you to go out and set up a trust? You have, is it Lisa? Right there, shaking your head. I'm sorry, I can't see it. Linda, I'm sorry. Linda, you were on a call. What did they tell you? Set up a trust, put your dinar into the trust, and if somebody sues you, they can't take your dinar from you. And in fact, I've talked to some individuals, they told me they were going to get a package deal. They could get 10 trusts for $5,000 if they for asset protection. And I asked them, I go, why do you need 10? Isn't one sufficient? Oh no, you got to break everything up. I thought to myself, and I asked them this, I said, if you have, I'm going to steal this. If you have one trust with all your cash and dinar in there, and it provides asset protection, why do you need to break it up into two separate trusts? It doesn't make sense, because asset protection is asset protection. If it's all safe assets inside of one trust, then you're protected. Now, what most individuals do not realize, with a grantor trust, it's not going to provide asset protection for you. A grantor trust will provide zero asset protection. The answer to this is false. There's no protection with the trust. And in fact, if you wanted to create what we call a self-settled trust, where you create it for yourself and put some asset in there, such as the dinar, and then on revaluation it becomes currency, and you're holding on to that currency and you're looking for protection, you would have to go to a jurisdiction like Nevada or Alaska and open up that trust. That is because those jurisdictions have specifically formulated legislation that permits a self-settled trust that will provide you asset protection after its creation. But what you also must understand is if you go down this road and you choose a jurisdiction, there's about 8 or 12 of them out there, I believe, that offer asset protection trusts, there's rules that go along with it. For instance, are you comfortable turning over control of your money to somebody else, like an attorney? Why not? No. Don't want to do that, but they don't tell you that on the call. Okay, so you'd have to turn over your money typically to a trustee who lives or resides in that jurisdiction. So if you wanted to set up a trust for asset protection, you wanted to set it up in Nevada, then you have to hire somebody there to serve as your trustee. Now, once the money's inside of there, if you want to gain access to your money that's inside of the trust, you have to ask your trustee, petition your trustee to give you money. Now, your trustee can decide yes or no if he wants to give you those funds, but if all he did was issue funds every time you asked for it, you just lost all your asset protection. Other things they don't tell you about this is that the assets typically have to be held in that trust for a minimum of 3 years before they'll be protected from creditors. or the assets actually have to reside in the state where the trust is created. So when we look at trusts, they're typically not a great choice for asset protection for you, for your investments, because you're not going to gain the protection that you're seeking. And it's not going to be as represented by most individuals. And what I've listened to, because I've listened to a couple of these calls, typically you hear the same thing over and over again. They're not attorneys. You don't need an attorney to do this. Anybody can do it. I have special trust that was set up by the IRS. It's been drafted by Scots on Trust or adopted by that, or I forget the exact terminology they use. But at the end of the day, it's not going to provide the protection people are seeking. But if you wanted to create a trust for your child, yes, you could get that type of protection. But for you, yourself, or protecting your investment, they will not work. Unfortunately, a lot of people that we've run into have bought into this and have created trusts with the false belief that should anything happen to them, they'd be sued, that trust is going to be there to protect them. So I want to get that out there so people know right away when it comes to trusts, trusts are typically not going to be used for asset protection. The answer is false. Here's another one. A C corporation will not save me on income taxes. I've run into quite a few people who have told me that they've placed their dinar into a C corporation that they put up or put together in Nevada or Wyoming. Now, do you think it's going to save you on taxes, Nick, if you convert your dinar into cash and it's held in a C corp? Nope. Why not? Absolutely. Nick says it will actually add to his tax base. It will add to your overall, the amount of tax you pay. Because when you place your dinar, this currency, into the C corporation, and you, after the RV, you exchange it into dollars, that is income to the corporation. It's income to the C corporation. The only way you can get that out of there is to either take it out as a salary or to take it out as a dividend. If you take it out as a salary, okay, it's going to be subject to income taxes, plus it's going to be subject to employment taxes. So now you've increased your tax bite on that. If you take it out as a dividend, it's going to be subject to 15% dividends tax plus the corporate tax rate as well on those investments. So overall, you'd be looking at about, I'd say a 45% tax bracket. Much better to keep it in your own name. I wouldn't use a C corporation to place any of your currency in. It will increase your overall tax rate. So it's true. A corporation will increase your taxes if you hold your currency inside of it. It's not to mention C corporations aren't good for certain types of things. But at this point in protecting what we have and where we're going to be in the future, we do not recommend you create a C corporation. That's something that's going to come down the road after the RV and you're looking to go out into the world and do different things with your money. Then we could consider utilizing this entity. All right. Insurance will most likely not protect me if I am sued. Here's an asset protection one. Do you think insurance is there to protect you? You say no. Why is that? What? Oh, okay. What she said is that the insurance companies care more about their own pockets than you. Do you really think that's the way it is? No, I wouldn't think that. I think the insurance companies want to help me. They're there to pay out claims, not deny claims. That's what they say. But then when they see on the news people down in Florida after hurricanes come through and you have hurricane insurance and they don't pay off, makes you wonder, doesn't it? Yeah, no flood coverage. That's right. Reminds me of two guys on a boat one time on a fishing trip. And there's a guy there, and they're sitting there drinking some beers, and they're fishing. One guy says to this guy who's an attorney, he says, "What are you doing?" The attorney tells him, he goes, "Oh, man, I'm down here living a good life. I don't have to work anymore. I had this huge fire, burned everything, collected on this huge insurance policy. Now I'm done." The guy says, "Great." The attorney looks over at the other guy. He says, "What happened to you? Why are you here?" He goes, "My business was wiped out in a flood. I collected on this huge insurance policy. Now I'm all done." Attorney scratches his head for a moment. He looks at the guy, and the guy says, "You have something to ask me?" He goes, "Yeah. How the heck do you start a flood?" So, you see, insurance companies are not there to protect you. Most people think that they are, and they'll find any way they can to get out of it. Typically, the claims that you're going to find where insurance companies will deny it, I'll give you a great example of this. There's an individual in New Hampshire, I believe it was, And he decided that he wanted to buy an ATV for his son on his 14th birthday. He said, this would be great. My son's always wanted to have a four-wheeler. I'm going to go out and buy one for him. But I'm going to be responsible with this. I'm going to make sure that we have sufficient coverage with our homeowner's policy, so should he get involved in an accident, that we're covered. So he went to his insurer and he explained to him what he was going to do. And the insurer says, don't worry, you're covered under your homeowner's policy. He said, great. Well, he went home and his wife said to him, you know, honey, I think we should just get a little more protection. Because little King, guys, the individual name was Mr. King. Well, little King, his son, she goes, he's kind of a rambunctious sort, so why don't you get a little more? So Mr. King went and obtained an umbrella policy. You know what an umbrella policy is? Okay, it's an additional liability policy that you get in conjunction with your homeowner's policy. Typically, you'll get them for $1 million umbrella or $2 million umbrella policy. And so if whatever they go beyond on the homeowner's policy, the umbrella policy will pick up on the claim. So he bought this $1 million umbrella policy. He went home and he told his wife, he said, hey, I did just what you wanted, honey. I got us a $1 million umbrella policy. She said to him, she goes, you know, I was watching little King out in the yard today playing around with his brother. I think we need a little more insurance if we're going to give him that four-wheeler. She goes, why don't you go get something else for him, honey? So Mr. King went out and he bought an excess liability policy for $2 million. So now he was covered with 3 insurance policies. Now stop at the story right there. If you need to buy 3 insurance policies in order to feel secure about giving your son a four-wheeler on his 14th birthday, don't. Okay? Just don't do it, because that tells you something's going to happen. Well, he did. He gave it to him, and everything was fine for about 20 minutes until little King's friend came down the street, saw him with this new four-wheeler sitting in the driveway, revving it up, and he goes, hey, little King. He said, yeah, little Johnny. He goes, why don't you pull me on my skateboard? Let me throw you some rope. So he threw little King some rope. He tied it onto his four-wheeler. Little Johnny jumped on his skateboard, and they went down the driveway into the cul-de-sac, and they took that turn, and little Johnny kept going. He didn't take the turn with the skateboard. Now, Big Johnny came and sued Big King for the damages that his son Little Johnny sustained when Little King took him on the ride on the skateboard. And so Mr. King then went to his insurance carrier and he explained to them what happened. He said, you told me my four-wheeler and Little King would be covered, and unfortunately an accident did occur on the first day in which we brought this home and presented it to him. We are now seeking coverage under our policy. What'd they tell him? They said, didn't you read the fine print? He says, what? You know, on the back of your insurance policy, that 8-point font that they write on the back of it, and real small letters, 10 pages, you got to read all of that. Hey, come on, how many people have read their insurance policies? Oh, you have, Mark? You're a better man than me. I have not read mine because I know it doesn't matter. There's no bargaining position there. Even though I'm an attorney, I couldn't go to them. excuse me, Allstate, I object to clause 12.6. I think we should amend this, and I'll write you a new one. Say, Mr. Coons, why don't you go find a different policy carrier for yourself then? So he didn't read the policy, and the policy stated that he was covered as long as Little King rode that four-wheeler in the front yard. Once he went off the property, no coverage. And the harm occurred in the cul-de-sac in front of his house, so he had no coverage. Now, we got nothing to worry about, right? We got $1 million umbrella policy and a $2 million excess liability policy. And so he went to his umbrella policy and he said, I need coverage. Big Johnny's coming after me with the big stick. Umbrella policy said, well, what did your homeowner's policy tell you? Those SOBs said I wasn't covered because it happened outside of the driveway. He said, well, didn't you read our policy? He goes, what is this with reading policy stuff? He goes, well, it says right here on page 9 that if your homeowner's policy fails to cover you or denies coverage, then we deny you coverage as well, and you're not covered under this policy. So he lost coverage there. Now, he has one more chance. So he went to his excess liability policy carrier and said, excuse me, I got $2 million with you. I've paid you good money for this $2 million policy, and I need coverage. And here's what happened. Little King goes outside the driveway, drops little Johnny on the concrete. Little Johnny doesn't look too good. Then I go to my homeowner's policy. They refuse to cover me. Then I go to my umbrella policy, and they refuse to cover me. Excess liability policy adjuster says to him, what? He goes, well, I just told you what happened. He goes, no, back up one step. You said you went to your umbrella policy? He goes, yeah, I have an umbrella policy because I wanted to put somebody else in line before they got to you to give you added protection. Well, didn't you read your application, sir? He goes, what do you mean my application? Well, it says right down here on the application that you must disclose every policy that you own. Failure to disclose all of your policies when applying for our policy allows us to deny your claim. And because you didn't disclose your umbrella policy, we deny your claim. Now, how did I find out about this case? Well, Mr. King appealed the trial court decision to the appellate court. And he said, this is unfair, it's unjust, okay, for what these insurance carriers did for me. I bought this insurance with the expectations I would be covered. Most people would know that if you buy a four-wheeler for a child, he's not going to ride around in the front yard and do donuts. I'm not going to let him. But the courts, they said, I'm sorry, sir, you had a duty to read the policy before you signed on the dotted line. And because you failed to read it, you did so at your own peril. And therefore, the insurance companies do not have to provide coverage to you. And so he lost on that claim. And so when we talk about insurance companies not wanting to cover you, that's exactly right. There is, in my opinion, very little comfort in having an insurance policy. I mean, we all have to have them. But if we were involved in an accident and a lawsuit, it doesn't necessarily mean that they're going to come up and defend you in the event that you need them. One of the attorneys that works for us used to represent insurance companies. And he's got great stories that he'll tell you about when he would go to these conventions. Insurance executives would get up and smile and say, this has been a banner year for us. We've managed to collect the highest amount in premiums and offer the least amount of coverage ever in the history of our industry. And that's the mindset that's behind it. So insurance is not there to protect you. The answer to that is true. Okay, how about this? I can convert my dinar into gold and avoid recognizing income on the conversion. I've heard that probably 100 times. And I ask people, where do you get this information? It's always some website, some phone call that they listen to. Okay, has anybody ever heard this one before? Does anybody believe it? Why not? Why can't you convert your money into gold and avoid it? Can you convert your stocks into gold and then avoid having to pay tax on the conversion from your stock in Apple? It's still an asset. It's still a change of the asset. You've converted something. Whenever you convert something, that, if it's an appreciated asset, that is a taxable event. There are certain exemptions to the rule. For example, 1031 exchanges for investments, real estate, okay, being the main one there. You can convert your real estate into other real estate on a 1031 exchange and defer the recognition of tax. But when it comes to securities and investments, that does not apply. So you cannot convert your dinar into gold and expect that you will avoid paying any income tax on that conversion, and the conversion will not apply until you convert the gold back into cash. Just not going to happen. The answer to that is false. Estate planning. Does a will avoid probate? Yes or no? Not in Kansas. Okay. How about in other states? Okay. Great answers. True or false? True or false? What do you mean? You got a 50% chance, you said.
I have a question on your last one.
Do you?
So what the Treasury's put out recently has always been there?
Okay. It's Greg. Greg's asked me what the Treasury has recently put out. Has it always been there? Okay. As far as I know, it has. I went and searched today before we started this class this morning on the Treasury's website, on the IRS website for that specific language to see if anything recently was announced or released. Nothing popped up. So my question then to the individuals who sent me the emails, I said, where is your source for this? And do not tell me Dinar Daddy or Dinar Trade as a source. I want to know the actual governmental source where you obtain this information from. Because that is what you should be asking people. Not, well, you know, Joe said this. Well, fine. Does Joe work for the IRS? Does he have the ability to speak for them? Because you have to filter this information. You have to understand that. So it's always been the rule that if you convert it, it's going to be taxable. It's always been the rule. Doesn't matter. Doesn't matter. It's still a conversion. A conversion is taxable. However you choose to take back the exchange, be it in gold bullion, be it in U.S. silver dollars, you're still receiving something in exchange. that makes it a taxable event for you. Okay, because you could imagine what individuals would do then. Sure. Now, first off, you need a pickup truck or semi to pull that many coins out. And I haven't been to a coin dealer and say, hey, you got a vault in back with $10 million in silver dollars? Get a shovel. All right. So, back to the will. Does the will avoid probate? You say, no, it does not. Eric, what do you think? You say no. Elizabeth? False. That's right. A will does not avoid probate. How many people here just have a will? A few of you? You do? Is that all you have, or do you have a living trust as well? Just a will. Is it a good will? Do you want to find out? Okay. How do you find out if you have a good will? Great, get some rope. Yeah, we don't know. See, with a will, you have to go through probate. What does probate mean? It means one of me gets to come and represent you. And attorneys work for free, right? False. There's another false one. That's right. Wills are not how you should handle your estate. And I can tell you this firsthand. Both sides of my family were destroyed over wills. My paternal grandmother, she nominated her eldest son to be the executor of her estate. And she passed away with a will. I could not convince my grandmother to set up a living trust because she just felt that, this is what her parents did. Bishop was the attorney who drafted the will. That's an attorney in Bremerton. And she felt secure and comfortable in that. And she figured maybe that my father, which was her son, might influence me. And my dad has a big personality, and he's very aggressive. And it might be to the detriment of her youngest son, because she left 3 sons behind. So, my grandmother passes away. 5 bank accounts, 2 pieces of property. Split 3 ways. So how long would it take you, Michelle, is it, to distribute out 2 pieces of property and 5 bank accounts to 3 beneficiaries?
A long time if they're arguing over it.
You're in complete control. It doesn't matter what they have to say. You just look at them and go, I don't care. Okay, go talk to the hand. How long?
Me personally.
How long do you think you can do it? Couple of months. Okay, that's fair. Anybody think it'd be longer than that? You're shaking your head. What do you think? Much longer? Why, have you taken longer than that?
Yeah.
You got exposed. Okay. Were there people bringing a claim against you, or not because you did anything wrong? They're trying to break the estate. Let's assume there's no problems. Now that's an aberration. If somebody's going to challenge the estate, absolutely it's going to take a long time. But in my case, with my uncle, I was the attorney, by the way, represented it, because as soon as my grandmother passed away, my dad looked at my uncle and said, you're not going to go to Bishop to have that attorney handle it. You're going to use Clint. He works for free for the family. I sent him to law school. This is what he's going to do. And I did. And my grandfather, he was still alive at the time, who was the attorney, he said, Clint, you got it all backwards. You need to be charging double whatever your uncle's charging, because you're the attorney. Now, what did my uncle charge? He charged $75,000. It took him almost 5 years to distribute out 2 pieces of property and 5 bank accounts. Why? Because he wanted to learn how to be an executor, is what he said. And how else was he going to learn if he didn't practice on his mother's estate? Now, what can you do in that situation? Nothing. Okay, my dad was upset, and my dad didn't need the money, but he was just the principle of the matter. He goes, I'm going to sue. I said, what are you going to argue? That your brother's a turtle and that he's stupid? And you think that's going to convince the court that he's going to be replaced and you're going to get paid back those fees? No, you're going to have to argue that he somehow breached his fiduciary obligation to you. Just because he's slow and he's not the brightest bulb doesn't give you a right to replace him, because grandmother chose him. Now, that didn't sit well with my father, but just the way the law works. And so at the end of the day, I explained to him, I go, if you did this, it's just going to cost you more, and he's going to get paid more because he's going to charge for his time in defending himself. And so I detest wills because of the fact that they leave everything open to chance. And For the people who own dinar, I've had several conversations with individuals regarding this, especially if it happens pre-RV. I've explained to them, I go, you have this money, we always think post-RV, but if you passed away in a car accident driving down the freeway on the way home after this event, and you have a safe at home with your dinar in it, what's going to happen to that? Who's going to be in control of that? Have you left instructions on how they're to dispose of that dinar? Because when it RVs, now all of a sudden there's going to be $10 million or $20 million for somebody. Has that gone through your mind? And most of us don't think in those terms. We think in today, not necessarily in tomorrow. And I think estate planning is extremely important because it should address today, tomorrow, and the hereafter. And that's what a good living trust will do for you. And that's why you should avoid creating a will for your estate plan, because it leaves too much to chance. And I would avoid it. And I'll leave you with one last thought here. Does anybody here own property in more than one state? More than one state? Okay. Oh, you do? Do you have a will, Jana, or do you have a living trust set up? Neither. You have a will. Do you have in your will, do you have that Winnebago clause in there? Oh, you got to have that. A Winnebago clause, okay, you got to make sure you have this. When you go home tonight, make sure look for this clause. It states that when you pass away, they're to hold back a set sum of money to go out and purchase an RV. And you want to have that RV, you want to paint on the side probate wagon. Because after you finish up probate here in Kansas, where's your other property owned? Texas. Your family needs to get on that bus and drive to Texas because they're going to start the process all over again. You cannot probate property in another state without going through probate there. So I run into people who end up purchasing property in multiple states, and they set it up in wills or they haven't done anything, and after their kids get done probating the assets here, they think, well, how about that property in Texas? Your Honor, you forgot about that one. He says, no, I didn't. I have no jurisdiction over that. You need to go hire an attorney in Texas and start this process all over again. And just think, if you have my uncle involved, you got 3 pieces of property, you're talking 15 years. It's a long time. So a will does not avoid probate. The answer to that is false. Another question that comes up a lot. Can I hold my dinar in escrow and assign the income after it revalues? People tell me, listen, Clint, what I'm going to do is as soon as it RVs, I'm going to go down, I'm going to cash it in, I'm going to put it in escrow. I said, okay, then what are you going to do with that? No, it's what you're going to do, Clint. You're going to set me up a charitable remainder trust, and we're going to get that all created, and then you're going to tell that, I'm going to tell the guy to hold the escrow to put it over into the trust. I won't have to pay any income tax on it, right? Wrong. Again, once you convert the dinar into U.S. currency, it's a taxable event. If you can direct those funds to yourself, it's your money. It's taxable to you. As long as you maintain control of that, you have to pay income tax on it. So an escrow account that's set up with the anticipation that you can move the funds into a tax-deferred account after RV will not relieve you of paying income tax on that conversion. What you should do, if you're interested, we'll cover this entity later on in the presentation. If you're looking to avoid recognizing income tax immediately on it, then you hold those dinar notes. You do not cash them in until you get an entity set up that will allow you to defer income tax. And then, after that entity is set up, take it down, cash it in, have the money transferred directly into the account that you just created. Any other maneuvering in that will subject you to immediate income taxation on that conversion. So the escrow. We're going to talk about that entity later. All right, so the answer to that is false. I can gift my dinar pre-RV without gifting the actual currency. This comes down to what constitutes a completed gift. Now, I'm going to give you now the legal definition of a gift. Well, I'm going to paraphrase what you have to do. In order to gift somebody something, you have to do this. Sherry, I want to give you this rubber band. Have I gifted the rubber? You just broke it. I didn't tell you to quit holding on to it yet. Have I given her the rubber band yet? Why not? Were you afraid I'm going to let it go? Yeah, you were thinking that. So was I. I didn't know if you let go first. Woo. All right, you can let go now. So, if I hold on to this rubber band, when I've said that I've gifted it to her, it's not a completed gift. If I say, hey, Sherry, here's a rubber band. It's yours. Is that your rubber band? Come on, snap me with the rubber band. You can't, can you? Because you don't have it. If you don't have it, it's not a completed gift. If I actually want to give her something, I have to give her the rubber band. Now it is hers. But people have called me and said, Clint, here's what I'm going to do. I'm going to tell my kids that I'm giving them this money, but I'm not going to give it to them. Heck no. They may go and spend it or give it away or do something crazy with it. I'm going to maintain it, but I've gifted it to them. Really, how do you do that? Well, I'm going to write down on a piece of paper that I gifted to them. Technically, that's not a completed gift. And the reason why people have asked me that and they feel it's important is because they want to avoid gift tax after RV. That is, when you gift it today, if I wanted to gift somebody $1 million, it's about $1,200. That's the cost of the gift. If I wait till it's after RV and say it came out at $2, that's $2 million I just gifted them. And I can only gift up to $5 million in my lifetime as it stands right now, which I'm sure it's going to be reduced down. You'll probably burn it up just on that million, your lifetime gifting amount, without paying any gift tax. Otherwise, I'm going to have to pay gift tax on it. So if you pay gift tax on a gift of $1 million, you know how much they're actually going to end up receiving after income taxes? Probably about 30 cents on the dollar. You just wasted 70 cents in income taxes. Now, the government's going to like that. Absolutely. I've read a number of posts. People are concerned about you being audited afterwards. If I was going to audit individuals, the first thing I would do was focus on all of their family members and check out the wealth that they've come into. And then I would go back to them and I would say, let me see, did you purchase these dinar yourself? No, you did. Or can you show proof that you bought these in your name? No, my parents bought them. Okay, did they give them to you? So they'll bring them in and start grilling them and asking them questions. When did they give them to you? Did you have actual possession of them? What did the notes look like? Give me the, I guess there's no serial numbers on them, but we can't read those, can you? That's what I said, I can't read them. So those, I didn't know what those things were, because at first when I was going to bring them over, I was going to write down all the serial numbers, and I started thinking, man, people got 10 million, oh geez, that'll be here forever. And I couldn't read them. So anyways, you see where I'm moving with this. They will question, and they will prod and poke, and you don't want somebody to crack, because, think about it another way. RV happened on Monday, and you wanted your child to have $1 million. You could just walk up to him and say, here you go. These were yours. I gave them to you 2 weeks ago, right? Yeah, Dad, 2 weeks ago. And then, as long as you're not audited, nobody comes and questions, everything's going to work out fine. But if you get questioned about it, they bring in your child and they say, now when did you get these pre-RV? The child says, 2 days. 2 days before. And then they go back to you. When did you give your child the dinar pre-RV? 2 weeks ago. What did he tell you? Oh, wouldn't you like to know, sir? So if you want to gift dinar pre-RV, you actually have to give them the currency. That's the legal requirement in order to make a completed gift. You have to actually give possession. That's why I showed you that rubber band example there. As long as Sherry had possession of the rubber band, she's in control. They're hers. She owns the band. But as if I keep a hold of that band, I've not given her the band, as long as I still hold on to it. I've not relinquished my control, so it's not considered a completed gift. All right. So the answer to that is false. All right. Asset protection. We'll start with this. How do we define asset protection? Okay, I've got a lot of calls on that. People are concerned about asset protection. I'm going to ask you why. How do you define asset protection? Ray, how do you define it? What comes to mind when I say asset protection? What are you thinking of? You want to make sure that somebody can't take it from you. Now, who's going to try to take that from you? Okay. So you're afraid that these guys are going to try to take it from you, right? This is an attorney, by the way. Okay, you're afraid that this guy is going to take something from you. So when we talk about asset protection, we're afraid of attorneys coming and taking our assets from us because we get involved in an accident and we're sued. Something you've done. Maybe you're out on the freeway and somebody stopped short and you rear-end them. And now they're going to sue you. Basically what they're going to do is try to find out how much you have before they bring that lawsuit and how much they want to fight. The more you have, the more of an attractive target you become. And you don't want to be on the receiving end of a lawsuit where there's a personal attorney, injury attorney involved, because they're going to go for the jugular. They're going to push and push and push to see how much they can get, because the more you have, the more you stand to lose, the more scared you're going to be. Asset protection at that point in time is not going to work for you. So when we talk about asset protection, what we're looking at, what I'm trying to define is, define it in your own mind. What are we trying to do when we create an entity like an LLC or a living trust? What are we trying to protect? Okay, so I would say we're trying to protect our dinar, our wealth. So we want to protect the dinar, of course, because it has value. It's going to have tremendous value after the RV. So that's one aspect. Anything else comes to mind when I say asset protection? Why did you want to come to this class? Put a name with a face? Boats and cars? Okay, so real estate. So you want to protect that. That's important. You don't want to lose where you live. Okay. What else are we looking to protect assets from? How about this guy? Okay, who's he? That's right. He's got his hand out, looking for money. Okay, so we want to reduce our taxes if we can, because I firmly believe I know how to spend my money better than the federal government. At least it would appear that way from what they've been doing. So that's a major concern right there. So taxes. Anything else that comes to mind when I say asset protection? No? Okay. Bank accounts, you want to protect your cash. Yeah. Well, let me show you what. This right here is my family. And when I think of asset protection, this is what I think about. So when people say to you, Clint, when you say asset protection, is it money? No, it's not house. It's what would happen to my wife and to my kids if something were to happen to me. That's what I'm concerned about with asset protection. So when I get on a plane and I'm flying back on one of these small little jets, we hit turbulence, I'm not concerned. I mean, most people, when they go somewhere, they hit turbulence in a plane, they're going to think, oh gosh, what did I leave behind? Who's going to get left behind? Is this all tied up? Is it all protected? My answer to that is yes, it is. My wife would not have to change her standard of living. She wouldn't have to go back to work. She could stay there and continue to raise our children in the manner they've become accustomed to, because I have sufficient life insurance on my life. In fact, I got so much, some nights, I sleep with one eye open if I upset her. I'm worth more dead than alive. But I'm serious. One time I was driving with my wife. She goes, how much insurance you got on you now? I said, oh, about $4 million. Really? That much? I don't like that smile. So when we say asset protection, that's what goes through my mind. I want to make sure that they're taken care of. That's everything that I do is so that my children, my wife, are going to be protected. And then my kids, it's all going to get passed down to them. That's the way I was raised. That's what my father had done. Is continuing to do. He always reminds me of that, of course. Why I still have to do free stuff for him. It's just that when I think of it, it's not so much the material. It's the other things in life that I think are extremely important. And so what we're going to be talking about, a lot of it all comes back to this at the end of the day. What we're trying to do is ensure that we leave a legacy for our children, our grandchildren, everybody else, so they don't have to work as hard as we did. Maybe they can utilize their talents in helping other people, which is, something that I think everybody wished they had more time to do. But it's hard to find that time today because you have to work so much. And it's just to ensure that life is better for everyone in general. And so that's what I look at that's how I define asset protection. All right, so where's the problem? Well, it starts with attorneys, number one. That's why we have to have protection. Look at this right here. This is an actual website. It's called whocanisue.com. If you want to bring a lawsuit, start your picks right there. You can go to this website and they will tell you who you can sue if you want to sue somebody. Now, I've had clients come to these events before, business owners who have been sued under the Americans with Disabilities Act because mirrors were placed too high in their public restroom by 6 inches. And they were held to account for that because somebody in a wheelchair could not see their third button on their shirt when they wheeled themselves up to the sink because they only could see from here up, and they're supposed to be able to see from here up with the mirror if it's placed at the right height. I mean, regulation in this country has gone way, way overboard. Okay, we try to regulate everything, like somehow by over-regulating, we're going to eliminate stupidity. Okay? No. Let those people eliminate themselves, and then the problem will eventually solve itself in 3 or 4 generations. I mean, think about it. When's the last time you had a wood burning kit? You don't anymore because they burn. People couldn't figure that out when they bought them and they brought them home. Well, I got burned. I'm going to sue somebody. Who thought it would burn skin? I thought it would just burn wood. Really, sir? Okay, so we have to put warnings on there. You go to whocanisue.com. Sue Easy. Here's another ridiculous site that should be taken down, but it's out there. If you want to bring a lawsuit, they encourage you to go there. They'll tell you how to get the lawsuit started. If you have a claim, if you don't, we'll find one for you, is how they advertise. Other things like this that I find to be extremely disgusting. Personal injury, Recovery Road, the next exit. Okay, you've been injured through no fault of your own. Call the law offices of William DiPolito and Associates, and we'll get you that just recovery. Now, do people go to these law firms because they read Johnson & Flora Inc. experienced personal injury? Or do their eyes go directly down here? 4.1 million, 3.2 million, lawsuit, lottery, that's what I'm going after. It's all in the numbers. That's why they put their verdicts on there. And you think these firms are reputable? I'll tell you firsthand, they're not. When I was in law school, my very first job was working for a personal injury attorney. When I remember, I went to the job board and I saw this posting for William DiPolito and Associates. I said, man, I remember that guy. Where do I remember him from? Oh, I know. When I would come home late at night when I was in high school and I couldn't fall asleep, and I'd turn on the TV, maybe watch it till 1:30 in the morning, and there would be an advertisement for William DiPolito and Associates at 1 o'clock in the morning. What type of law firm advertises at 1 o'clock in the morning? Kind that's looking for hardworking individuals that have to get up at 6 a.m. and go to work? Or the people that don't have a job, they're not looking to do anything the next day. But they're saying to you, hey, you want to claim? You come see us, we'll get you some money. Well, I went to work for them. Why did I go to work for them? Because when I first started in law school, I saw the numbers. We'll pay you $300 a demand letter. So I went to this attorney, I interviewed with him. He says, hey, are you a creative writer? I said, absolutely. I'm taking creative writing right now. I think I am a creative writer because that's one of the required law school classes. He said, well, great. I've got a job for you. Here's what I want you to do. I want you to take this client file and I want you to put together a 10-page demand letter outlining how our client was injured and how their life has been affected as a result of the injuries they sustained in the lawsuit that was a direct result of the defendant's actions. And we're going to serve that on the defendant and his insurance company and look for money. And we're going to get paid. Well, I'm going to get paid and you're going to get $300. And I said, okay, well, how many of these can I write? He goes, how many would you like to write? You got 10 of them for me? So I said, $3,000. Here I am, first-year law student, first semester, making $3,000 for writing 10 letters. He goes, I got 10 files for you. He goes, let's start off with the first one, though, to see how you do. So he gave me the file. Let me borrow this right here. And the file was like this thick. It contained 2 pages. Looked at it. You got more? He goes, you don't need any more. I said, I don't. Really? He goes, yeah. You have the accident report and you have my notes. I said, but you want me to put together 10 pages? He goes, I know I do. And you said you were a creative writer. So if we put 2 and 2 together, we've got 10 pages, do we not? I said, are you serious? You want me to make stuff up? He goes, we don't make anything up. We just tell the truth in this law firm. And so what I want you to do is put yourself in our client's position. How would your life be affected if you sustained similar injuries in a similar accident? What do you think would happen to you? I said, all right, so I'm going to put myself in their position. I'm going to write how my life would have been affected in the third person, and you want me to do what with that? He goes, you bring it back to my office, I'll pay you $300, and I'll go through to make sure, I'll talk with the client to make sure this has actually occurred, and I'll make any changes that are required. And so that's what I did. First year of law school, I would write those things, and I was making really good money because I saw it as a cash machine. All I had to do was put out 10 pages, and I got $300. And so my first year of law school, I don't know what I made, maybe $36,000 that year, close to it, something. No, not that much. But I made a fair amount of money just writing demand letters. And the point is that eventually I quit doing it. Any idea why? What'd you say? Conscience? You've never applied to law school. You've never applied to law school either. If you put you're an honest attorney with a conscience, you're not getting in. Okay? They're looking for just the opposite, right? You have any morals? No? Good, come on in, join the club. No, it's because I lost creativity. I couldn't do it any longer. I didn't know what to write. I found myself taking the old ones and rewriting them. In fact, I got bored is what happened. And then I decided to go do just the opposite. I decided to go work for the prosecutor's office. And I tell you, you think that's any better? There are just as many of the screwballs in the prosecutor's office as there was on the other side of the fence. That's why I decided to do asset protection, because I couldn't get along with anybody. So this is a real problem. And why did I say that? Because the prosecutors that I worked for, they were allowed to moonlight. They could do other stuff so long as it did not conflict with their jobs as a prosecutor. And the 4 gals that I worked for, they did probate and personal injury. And they looked at me and they said, hey, didn't you used to write these things? I said, yeah. She goes, so you're a creative writer, huh, Clint? I go, God, here we go again. And I saw that go, nothing's changed. I mean, you just put a different name on them, they're still the same person underneath that coat. They're looking to make a buck off of somebody else or the insurance companies. And what is the cost to society? We allow it because we don't want to serve on jury duty. We don't want to send a message. We can't get Congress to change the laws to make it that if you bring a lawsuit and you lose, you pay the other side's attorney's fees and costs. I could sue you tomorrow. Doesn't cost me anything other than filing fees, and I could sue you and make it last for 3 years. And Michelle has an attorney that she pays $50,000 to, and then I lose in court. Who really lost? She did, because she spent $50,000. She didn't win. She lost. She cannot recover those fees from me. That's the way our legal system is set up. We don't want to discourage lawsuits because the thought process is, oh, the downtrodden then would not have a voice. Well, they got too much of a voice right now because there's attorneys out there that troll for them. Here's another one, same thing. This was an advertisement. Both these are out of my bar journal that I receive every month, which is a useless magazine to pay for. All right, so another thing, other challenges, how to protect your wealth from a tax standpoint. Okay, there's ways to do it. Most people don't understand it. Brace yourself. The chances of being audited are rising. So if it happens, you hear what to do and what not to do. This was from the Wall Street Journal last year. There's another one from the LA Times talking about taxation. Here's the IRS's or the government's response to the deficit. The way we're going to cure the deficit is not by raising taxes right now. Is it by cutting spending? Oh, sure it is. We're going to cut $8 billion. That's a step in the right direction towards $13 trillion. How you get there, I don't know. But anyways, they're going to enforce the current tax code. And the way they're going to go about doing this is by increasing audits, and you've already seen it start. They believe that there are a set number of individuals out there who underreport their income or do not report their income, and that if they were able to capture that income, it would generate so many more billions of dollars a year in tax revenue that we don't have to do anything different. All we have to do is get those people who are not paying to start paying into the system, and we'll solve a lot of this problem just through forced compliance. So let's just start auditing people. And that's what the IRS is doing now. They're increasing their audits of individuals as a means to collect additional revenue. And they're putting burdens on people. For example, if you own rental real estate, you're considering getting into that. If you hire somebody to come out and work on your property, now you have to 1099 them if you pay them more than $600 in 1 year. Never used to have to do that. Now we're forcing us, putting the burden on the individual taxpayer to do more for the government because they can't do their job and get people to pay taxes. So they're going to say, we're going to draft all of you to report on them, make our job easier. And we'll collect money off of them and solve the issue. But it won't. So you have to appreciate this, and that's why when it comes to some of the planning we're going to be talking about, we take, I would say, a very conservative approach when it comes to structuring our clients. I mean, I have no problem looking in the gray area. Okay, that's fine. But you have to understand where the black and white area is as well. And there's certain lines we do not cross. And so you may have questions about offshore strategies. I won't be covering offshore at all. And it's not to say that offshore is bad, but from my experience in offshore, there are some people who take the approach that it's wink, wink, nod, nod. If it's over there in another island, then it's not mine. I don't have to report it because I didn't earn it. Okay, that's going to get you a one-way ticket to an orange jumpsuit and a cell with Bubba if you want to go down that road. And I can tell people who've ended up there. So we choose not to engage in certain types of transactions that we feel as a firm are risky for us. And it's because of our own lack of knowledge as well. I know where my knowledge lies, and I'm not going to step outside of my comfort zone. All right, so why does a lot of this happen to individuals? Well, number one, procrastination. Okay, you think about something too long, oftentimes it becomes its undoing. And that we just think, hey, we'll just wait. We'll worry about this issue at a later date. Well, taking that approach might get you into trouble. There's a great story that Greg tells a lot of times about an individual that called him up. See, we taught a seminar, workshop to some real estate investors on asset protection. We sat down with them. We told them, you need to, this one individual, you need to do this, this, and this, and protect yourself. Because if you wait and you get involved in a lawsuit, it's too late. That horse has left the barn at that point in time, and we're not bringing him back in the corral. He's gone. There's nothing we can do for you. So this individual chose to wait. He gets home. Next week, Greg gets this call from this individual. We'll call him John. John says, hey, Greg. Now, when somebody whispers to you and you're on a phone, you say, what's up, John? He goes, do you hear that, Greg? He goes, no, John, why are you whispering? Because there's somebody outside my door. Hey, we know you're in there. Open up. He goes, well, John, let's just talk normal. What's going on? He said, hey, somebody's outside my door and they have papers and they're trying to serve me. What should I do, Greg? We need to get asset protection in place. John, didn't we just have that conversation 4 days ago? Yeah, so let's put it together now before I answer the door. What do you think our response to that was? Too late. Can't help you there, John. Go answer the door. But they're going to serve me. Well, that's fine. If they don't serve you there, they're going to serve you at work. So if you're going to get served, you might as well get served at home. So the only people that know about it are you, and hopefully your neighbors aren't looking outside the door. What's going on over there, John? What's that guy want to do to you? So as long as that's not happening, we're fine. Just take it, okay, and deal with it. But if you wait too long and procrastinate, then you can find yourself in problems when it comes to asset protection and also with taxes. People procrastinate with planning for their taxes at the end of the year. We see a lot of people come to us in December, and they say, Clint, I would really need some tax help now. I said, okay, you giving me 20 days to put together a comprehensive tax plan for you for 2010? Do you really think we can do something in 20 days? This should have started in January, but instead, many individuals, when they contact us, wait till December. And we can't do much for somebody at that point in time because it's taken too long. So that is a problem. That's what stops people from moving forward, we've found. All right. Before we get into when do you need protection, let's do this. Let's take a 10-minute break. Got some coffee over there, and you got water, and then we'll start up again here in 10 minutes. If you have any questions, feel free to use Bob, Greg, or myself. We're here as a resource. So, the question, when do you need protection? This always comes up. Every call I have with somebody. Do I really need protection now? So do you need it now before you make it? Or do you need it after you've made it? Before. Well, that's first. Most people say now. Why do you say before? Back row? Because if you don't have it now, you won't be able to get it then. I think I know where you're going. Let's put this in a different context. What's your name? Doug. Oh, yeah. Doug, the loser of the dinar. Doug Dinarless. So, Doug did not lose his, well, actually, Doug did lose his dinar. Clint found it. Clint's worth $10 million. Doug is worth $100,000. We'll give him some, okay? Because I found one to note, then I gave it back to him. So he's worth $100,000. I'm worth $10 million. And we're both sued for $1 million. Who has more to lose? Any idea? Who has more to lose, Doug or Clint? Clint. Okay, let me put it to you different. This is what people think. They say, well, Clint does because he has $10 million. We're sued. Each of us are sued for $1 million. So let's assume they're successful. Doug, you pay $1 million. You're worth $100,000. How much do you have left? You've got a $900,000 judgment that's going to follow you around for the rest of your life. Clint has $10 million. He pays $1 million. How much does he have left? $9 million. So, is Doug in a better position or is Clint in a better position? Clint, because I got $9 million. Who needed protection more, Clint or Doug? Doug, because he wanted to keep his $100,000. I can spare $1 million. He can't spare $1. But we become so conditioned by CPAs that you don't need protection until you get to these places where you have $10 million that people often assume that that is the appropriate way for asset protection planning. And I run into these CPAs when people will go back with the structure I created and show it to their CPA, and I get on the phone with them. You start saying, well, I've got 5 clients that do something similar, and not one of them have ever been sued yet. Okay, well, so since it hasn't happened, that means we shouldn't plan. Yeah. Well, have you ever been in a car accident before? Never. Good, then I assume you don't carry car insurance, because why should you if you're never going to be in a car accident? Well, that's different. Really? How so? That's when the conversation typically deteriorates at that point in time. Because I'm just using their logic, but it only works from their side to me. So it's after you made it, no, it's before you make it that you need it. Now, what's the problem here? We find that people have fear of asset protection planning because they don't understand it. What do I refer to this as? Fear, false evidence appearing real. Okay? You do not understand where the risks lie. You don't understand what's there to protect you. And because of this fear, a lot of times people do not plan because they don't understand. All right, so let me talk about some myths here. Okay, we already addressed this. Only wealthy need protection. Number 2, okay, in this is that you're not likely to be sued. You know that the average individual will be sued 5 times during their life? 5 times. My father, he's already been past that. He was involved in a lot of lawsuits when I was growing up. He had 0 protection. His father was an attorney. My grandfather never once told my father to create some entities to protect himself, to discourage lawsuits, because my grandfather did not specialize in asset protection. He didn't understand it. He was a general practitioner, focused mainly on personal injury, wills, and divorce. He did set up corporations and stuff occasionally for people, but it wasn't his forte. So it wasn't at the top of his thinking when he sat down and worked with someone. So my dad would be involved in lots of lawsuits, I remember as a child. Now, when we look at this number, 5 lawsuits, I'll put it in perspective for you. My mother-in-law, she waited. She waited until I got out of law school. And then she said, happy time. Lawsuit accelerator, let's go. 5 lawsuits in the last 14 years. And who's had a defender every single time? I have. You know what the worst part about it is? She owes our law firm $60,000 in fees. How much have I collected, Tammy? Why is that? Why would you say nothing? How do you know? What? Yeah, that was in the marriage clause. I didn't read the back page of the marriage agreement in the fine point 8 font. I think my mother-in-law and my wife work for insurance companies because it said right there, she showed me, hey, if mother-in-law needs help, Clint, you do it for free. And I have. And it's crazy stuff that my mother-in-law does because she knows she gets it for free. She doesn't think, she just does. I mean, the major case that I dealt with her on, she built a garage 5 feet over the property line on the neighbor's property. You're good people. You're shaking your head saying that's all wrong. You shouldn't do that. Not my mother-in-law. Because neighbor found, this is where it gets really interesting. You know how the neighbor found out? Because my mother-in-law lives right next door to her twin brother. See, I think the brain power there was split when they were born. And twin brother one day got mad at twin sister. And so he went over to the neighbor on the other side of twin sister and said, hey, my sister built a garage on your property. Neighbor said, how do you know, twin brother? He goes, I helped build it. Which he did. I told my mother-in-law she should have that property surveyed prior to building it. No, she was going to do it her way. There's no way of telling her otherwise. Okay, she's very strong-headed. But then, when the neighbor sued, she comes crying on my doorstep. She goes, help me. Why? You did something wrong. No, I didn't. I said you built on their property, but it's not wrong. Why is it not wrong? Because they ain't using it. How's them logics right there, huh? Gosh. So, here's where I'm going with that. So I defend her. And worst part about a lawsuit, have you ever been involved in one? You know what? Well, one of the worst things about it is the fees. The other party had spent probably about $45,000, $50,000 by the time we get to deposition. Because I'm just thinking maybe I can get this on an adverse possession. I'll just drag it out long enough and the other side will finally give up and maybe settle and we can buy it from her. But no, wasn't going to happen. They were going for it the whole step of the way. But eventually, when somebody on the other side doesn't have to pay and you're shelling out $4,000 a month to an attorney and it doesn't feel like you're getting anywhere, that starts to gnaw at you. And we're in a deposition. And I look over at opposing counsel and his client. I said, you know, time out. Ma'am, did your counsel inform you that you can't collect attorney's fees at the end even if you're successful? They're not provided for in this state or by statute. And did he also inform you that I really don't do this for a living. I just do this because I have to, because she's my mother-in-law and I'm not charging her, and that my job is asset protection. I've structured in such a way that even if you are successful, you won't get anything? Right about then, fireworks happen. The other attorney, you can't be talking to my client that way. I don't care. At that point in time, cat's out of the bag. Once that's out, we settled 3 weeks later. She had to cut her garage back, of course, but all this other nonsense about $100,000 in damages and paying attorney's fees, that's all went away. And there was truth in that if they had been successful, we're not going to be able to recover against my mother-in-law because I had already set her up in a manner that would protect her against individuals. Because I saw the problems, the writing on the wall when I got married, that she's going to do what she's going to do. So, not likely to be sued? Not likely. All right, so insurance will protect me. We talked about that. Insurance will not protect you. Okay, here's an example. Is your insurance leaving you exposed? Here's what it doesn't protect against. Multi-million-dollar claims. Average insurance policy. Okay, you're typically covered to $500,000. Some people $750,000. The average claim or judgment is typically $1 million. So there's a gap there that you have to make up the difference with. Environmental claims. If you ever buy real estate, be extremely concerned about environmental claims. Environmental claims is when they find stuff in the ground. You live next to water, stuff that's leached into the water, you're responsible. Doesn't matter if you didn't do it. fact is, you own the property, you have to clean it up. I have a client right now in Gig Harbor. I structured her about 8 years ago. She's being sued for $2.5 million over an environmental claim right now on a piece of property that she owned 30 years ago. So how's that for things in the past coming back to bite you today? Now, I've told her, I'm not representing her in this, a friend of mine is, and he's a litigation attorney, but he's of the mindset, hey, this is a client, this client will pay me an hourly fee, so I'm going to fight it. Because he called me up and said, hey, she's being sued for environmental claim. And I first asked him, well, she kept everything in place and did what I said, got a HELOC on the house, got the LLC we set up for her, all her cash is in the LLC, pull that money out of the house. What do we got to worry about? He goes, well, we have to do certain things. I said, I wouldn't. I would just call up the other side and say, so what? Bring it your best shot. There's nothing for you to collect anyways. But unfortunately, what's going to happen is she's going to probably pay my friend probably about $15,000 to $20,000, and at the end of the day, she's going to be in the same situation. She'll end up settling with them because they're going to look at her assets. They're going to realize there's nothing for them to collect against. I'm maybe more cavalier on that, but if you set it up right, it doesn't matter. You can bring that claim against me because there's nothing for you to recover against because there's nothing for you to attach. That's very important when it comes to asset protection. But environmental claims will leave you exposed. Business failures, insurance won't cover that. Bankruptcies, you won't be covered there. IRS audits, contractual disputes, bank deficiency judgments, okay? These are things that insurance does not cover. You know, talking about banks, for instance, here. I know a lot of people are concerned about banks, about a bank going under. You know, if you have a loan with a bank and they're concerned about their overall risk exposure on that loan, they can take your account from you. It's happened to some of my clients that were in real estate. They've lost their accounts. One client of mine in particular is fighting a bank in Montana right now who took $2 million out of his account. One day he has $2 million in the account. The next day he wakes up, he goes to pull some money out of it. It's all gone. Calls the bank up and says, hey, I think there's been fraud. Somebody stole my money. Bank says, no fraud. We took your money. That's not fraudulent. Well, why would you do that? Well, we were concerned about that loan that you might not be able to bring this project to completion, so we took that as collateral now. He said, well, okay, well, can I get and I need to then draw on my construction loan? Oh, no, we've cut that off as well because we're concerned about this project. Well, how am I supposed to bring this project to completion? That's your problem, not ours, but if you don't move along on it, we're going to foreclose. And then they started foreclosure proceedings on him. Now he's in litigation with the bank over the bank taking this $2 million without notice. But it just goes to show you what can happen in a blink of an eye. If somebody were to sue, if I were to sue you and get a judgment against you, the first thing I would do, if you had money in your own name, I would garnish your bank account. That's the easiest way to get paid. People don't understand it. That is catnip to attorneys. If you keep money in your account, your personal bank account, because all I have to do is serve that judgment on the bank and they will hold those funds for me. They will not distribute them to you, because if they do, I get the money from the bank then. So banks are a risk to hold a lot of money in there. Forget about the bank going under. If you got sued, they'll just hold all your funds for your creditor. So you got to be careful. All right, so the idea here is to judgment-proof yourself. I like this picture. The reason I put it up there is because the guy's standing around going, hey, man, I got nothing. What are you going to take from this individual if he pulls his pockets out and there's nothing there because nothing is in his own name that the creditor can attach? The answer to that is typically there's nothing to get. You're not going to get paid. And so you have to understand that you can put yourself in that situation. You do not want to find yourself in this situation. What is this? It's a lawsuit. Anybody here been sued before? You have? Greg, what was it like? Did it feel like this? Feel like you're staring down the barrel of a gun? You had a good... Really? Is there such a thing? Was he honest? What's the difference between lawyer and liar, Greg? It's pronunciation. Yeah, you don't want an honest attorney. So, there's key words here. You don't want an honest attorney. Because, I mean, they'll come in, they'll say whatever. Well, Your Honor, our position is, liar, liar. When I used to represent, I worked on the defense side as well, my third year of law school, so I did it all. And every guy I represented, because I got to go in as a Rule 9 intern into court, and I was able to handle my own trials and represent people, and because the attorney I worked for had the municipal docket for 2 little counties there, or cities. They were all guilty. And if they weren't guilty of what they were accused of, they were guilty of so many other things, they all needed to be put in jail. But I had to defend them. And so every time I would talk to the judge, I'd say, Your Honor, the defendant has informed me. And I told him ahead of time, whenever you hear that, it means that I am now telling you this is a lie. It's a BS. And I don't believe what he's told me at all. And I had a very poor rate of getting people off, I'll tell you that. All my guys went to jail. Nobody wanted Clint to represent them. It's because I didn't want him around. I was a free attorney, and these guys would pull out these little fancy cell phones, start talking on them, doing their drug deals or whatever they'd be doing. I'm looking at him going, what do you mean, you need me, but you can afford that $500 phone? Something's not right here. Yeah. So, where were we? We're talking about Greg being sued. Was it not like being staring down a gun, though, when you got served that first day? Yeah, make you uncomfortable? What's the worst part about a lawsuit? What's that? The unknown. That's right. Martha, is it? Ruth Ann. It's the emotional factor. Money, yeah, that's expensive. We understand that. Attorneys don't work for free. But it's the emotional factor of not knowing where that lawsuit is going to go and how much you're at risk for is what gets people. And I can guarantee you the first thing that goes through somebody's mind when they're being sued is, how much do I have at risk? How much can they take from me if they're successful? You go ask your attorney, hey, is this a frivolous case? Can we win? And he'll say, yeah, we'll win. You guarantee that? Well, there's no guarantees in law. Let me explain to you that, because it's always going to be a jury pool. If it's made up of Clint's mother-in-laws, then there's no guarantees for sure. She loves to serve on jury duty. She thinks it's like Jerry Springer's show. She runs down the courthouse, pick me, pick me. Literally, she's on jury duty probably 4 times a year. I don't know how she does it. So when you get sued, the first thing that's going to go through your mind is, what is at risk? Do I stand to lose? Because they're going to take it. They get a judgment against you. They get to bring you into supplemental proceedings, and they get to ask you what it is you own. And you have to tell them. You cannot lie, because now you're under oath. You don't have to tell them ahead of time. But once they got a judgment against you, then they get to find out what it is that you own, and that's where the risk lies right there, because if you have dinar, you're going to have to disclose that. I've got 10 million dinar. Really? Where's that held? And you have to tell them where it's at. It's in your own name, then it's exposed. You do not want to get yourself in that situation, because number one, as I stated, it's extremely emotional. Has anybody been deposed before? No? You've never been deposed? Don't want to be deposed. Why not?
Because of what I've seen on TV.
Yeah. It's literally like that. She says what she's seen on TV. When you depose somebody, okay, you're going in to battle. With my mother-in-law, when I deposed her twin brother, okay, we walked in, he thought we were friends. I never really liked the guy because I saw him as a user. And when we walked into that deposition, it was all giggles and aw shucks and this and that. Let's go to lunch afterwards because I was deposing him. Well, during that deposition, at one point, he got up and he was going to take a swing at me, and they had to remove him from the room. Another time, he was crying like a baby in front of me. And then when he left the room, it went on for about 6 hours, this deposition, he told me he was going to have me disbarred. And to this day, he's always telling my wife, I could have him disbarred for the questions he asked me. He can't. But, he's a big talker, but I did my job, which is to go in and interrogate him and ask him questions that are way beyond the bounds, because I wanted to get him in an emotional state so we could get the truth out of him, because he was a liar. And I would start off questions like this. Greg, you want to role play with me? Not really. Is your wife here? Hold on to that. Hold on to that thought. Greg, how long have you been married? 17 years. 17 years. Okay. When were you married? What's the date of your marriage? March 26, 17 years ago. Hey, you're close. Most times guys don't get the March. It doesn't matter the year, does it? Just as long as you got the day. Yeah. All right. You have any kids? 2? How old are they? Wow, one's out of the house and one's almost there.
Which one's?
Yeah, which one's out of the house? Okay. Great, where's she going to school? You still being unfaithful to your wife?
Never have been.
Well, when did you quit cheating on your taxes?
Never have.
Can I ask him those questions? Absolutely. All right, give Greg a hand, guys. He did a good job there. Thanks. I got a book for you, Greg. There's a book in the back called Tax-Wise Business Ownership. I'll give that to you as soon as we're done here for playing along with me. All right, so this is the thing. Lawsuits, they're designed to scare you. They're designed to take from you. And you have to understand there's ways to protect yourself because you don't know where it's going to come from. You're a threat. How many people still have young children at home? Okay, several of you. You think they're a threat? Really? Like, what could they do to you? Come on. They could get you sued for doing what? Being stupid. Okay, yeah, well, that pretty much classifies all teenagers in that one, doesn't it? Hey, Clint, I created the most liability for my father than anybody could ever done in his entire life. He doesn't know it. I've never told him. But when I was a kid, you know, high schoolers, what are high schoolers going to do even though you tell them they shouldn't do it and you don't want them doing it? Drink, right? And drive. And hopefully not drinking your beer. So when I was in high school, I used to have to drive to Wildcat Lake, which was 30 miles away in order to buy beer because this store was out in the middle of nowhere and you had to drive 35 miles an hour all the way out there and 35 miles an hour back. So it would take you approximately 2 hours because you're not going to drive over the speed limit if you've got beer because you'd walk into that store and say, "Are you 21, Clint?" "Yes, I am." "Okay, here you go. Don't tell them where you got it." Never would. So I realized after driving this 2-hour round trip that I can do better than that. Hey, I'm a future attorney. Think like an attorney, Clint. Your dad has apartment buildings. He has apartment managers. You're down there every weekend working for him. You get to know him. Why not go to your dad's apartment managers and ask them to buy you beer? And that's what I started doing. So I would go and have my dad apartment managers purchase beer for me. And, you know, I then figured out, why am I going to buy it? Because my friends are in the same boat. They don't want to drive 2 hours. So I invited some of my good, close friends with me. And I said, listen, it's my dad's apartment manager. I know him. You guys have to pay for me. And we all get beer. Now, we drank really cheap beer because when I went to my dad's apartment manager, he would say, "Okay, I'm going to buy you beer, but for every case I buy you, you have to buy me a case." So I grew up drinking Lucky brand beer, which is like $4 a case. Didn't impress any girls when you brought that to a party. But anyways, the point of the story is that when I wouldn't be able to go out, I made this introduction to my dad's apartment manager. My friends started going to him, my dad's apartment manager, to buy beer. Luckily, nobody ever got hurt. But if somebody would have been involved in an accident, where do you think that liability would have came back to roost? Right on my father. My father was not protected. I wasn't thinking. I mean, I only saw what was right in front of my face. Here's an opportunity. This is going to create this much for me, you know. People are going to like it. Let's go for it. Didn't see the long-term implications of engaging in that type of activity because we're young, we're immature, and that's why we don't give children assets at 16 years of age or at 18 years of age. We tell them, until you can establish maturity, maybe when you're 45 or 60, we will give you those assets. And so you understand that risk, liability, you can't predict it. So what you can do is protect against the unknown. And the way we protect against the unknown, especially with denars, I have recommended that you create a limited liability company to protect your investment. Now, why do I make this recommendation to create an LLC? It is because an LLC provides two forms of protection. Now, this initial protection doesn't really apply right now to currency, but I'm going to explain it to you anyway so you get a good understanding of how LLCs work. LLCs will provide inside protection as well as outside protection. So, yes? LLE are limited liability entities. They cover limited partnerships and limited liability companies. All right, so limited liability companies look like this. They're boxes. Okay? Now, this is a limited liability company right here. These are assets, these pieces of candy. So I have the orange and the yellow. Those represent dinar, $25,000 notes going in there, a whole bunch of them. And I've got some blue ones, which are rental property that I have. I'll put that in there. And then I've got a bunch of other stuff. Cash as savings, maybe put a vehicle in there. And I don't know what else you might have, some gold. I throw it all in there. Now, does this protect me? Absolutely. Because with LLCs, when they're created, these boxes, you've just boxed up all of your assets. So you own the box. You no longer own the assets themselves. You own the box. So as the owner of the box, you're insulated from whatever happens inside of the box. So if you have assets inside of here and something happens and a lawsuit develops inside of the box, anything happen to me? Has anything happened to me? No. No, nothing's happened to me because I own the box. The box can have all the liability at once, but nothing happens to Clint. You see the asset protection there? You see how I'm unprotected? Because the liability stays trapped in this box and I can just throw the box away afterwards. And all that problem that happened inside of here will stay with the box. But is that asset protection? It doesn't sound like it, does it? Because what did I put in here initially? Everything. Yeah, but what were those things? NARS, yeah, but weren't they hard pieces of candy? I put in hard pieces of candy into one box, a whole bunch of them. And look what's happened because of one lawsuit. Do not come up and talk to me and say that you slipped on a piece of candy. Okay, I've now warned you. There's candy on the ground up here. I'm sorry I took your candy. All right, the point is that the candy, you put all the assets into one box. We put dissimilar assets into here. One lawsuit turned it all into sugar. Everything was at risk inside of this one box. So when we talk about asset protection, we're going to break your assets up based upon asset classifications. That is, if they're safe assets, put all the safe assets into one box. So can I borrow this one right here? What's your favorite flavor, orange or blue? Okay, we'll leave some oranges here. You like purple? Okay, so if all of this stuff is safe, this is all dinar and cash and gold, goes into there. You know why? That's never going to create liability for you. You're not going to be sued from holding that type of asset because it doesn't do anything. People aren't getting hurt. What, are you going to have somebody over and say, look at the dinar. Here, you want to hold one? As soon as they grab it, you pull it back real quick and give them this sharp paper cut across their hand. And then they start screaming because they're hemophiliac. And they start bleeding out right there, and you can't staunch the bleeding. Does that sound absurd to you? I think so. And so I just thought of that off the cuff. That'd be the only liability you might ever have from owning dinar inside of a box where somebody could sue you. But other than that, nobody's going to get hurt. So put all of your safe assets into this one box, and you will be protected. And this is from outside protection, because when I put safe assets in here, I'm not concerned about something happening in there. What I'm concerned about is something happening on the outside of the box. That is Clint being sued. Now, my real estate that you own, and this, I know only a few people said they have rental real estate right now, but if you have real estate, it wouldn't go in this box. You would create additional boxes. So you would have something that looks like this. No, back to there. Come on. You would have a box here. This would hold your cash, dinar. And then you would create a separate box for real estate. Now, would I put all of my real estate into one box? No. I would break these boxes up for the dangerous assets based upon your overall equity value. So I look at the property and say, how much equity do I have in this property? If I had three pieces of property and two of them had equity, the total equity here was $350,000, I might put that in, both of them into one. And then I would say for my third property, if it had $250,000 in equity, I would stick that into a third limited liability company. So now, if anything happened with this LLC right here, LLC number 2, this is number 3, this is number 1, you're down here and your wife's right here, okay, as well, and you guys own all of these LLCs. If anything happened with number 2, then the only thing you stand to lose is what's in number 2. What's behind door number 1 and door number 3 remains protected because it's a separate legal entity. You boxed up your assets, you have different boxes here. Whatever happens inside of the box stays inside of the box. And that's why we use limited liability companies for our investments from an asset protection standpoint. We want to break the assets up into different asset classifications. Now, the other benefit these entities provide is from outside protection. That is, Clint going down the apartment manager and buying beer, okay? Or you're involved in a lawsuit because you built property on somebody's, or built something on somebody else's property, or you're involved in an accident. And believe me, strange things happen. Now, understand that this example I'm about to provide you comes from California, the land of fruit and nuts. Yeah, it's strange, and you have an attorney that represents them. There are more attorneys in California than any other industrialized country in the world. Okay, that's the problem we have down there. I mean, that's in one state that I know of where somebody sued, brought so many frivolous claims, now he's barred from ever bringing another case in the state of California unless he gets leave of a court. Because he teamed up with an attorney, they go around and sue businesses, saying they violated the ADA, Americans with Disabilities Act. And finally, they caught this joker because he said he was at two different businesses all the way across town at the same time on the same day. And they said, wait a minute, how could you be 50 miles here at the same time? When you said you're here in LA, but you also said you're over here in a different county on that day at that time. So they found out they were running a scam. Well, our client was driving one night, and he had the green light. He was going through an intersection at a safe rate of speed, and somebody came along and T-boned him, a drunk driver. Now, the good news is my client was not severely injured. He was injured. I mean, it hurts to be hit. Okay, I could write together a 10-page demand letter that would get you about $12 million, but we'll figure that one out later. So he settled with the insurance company that represented the drunk driver. The drunk driver, of course, was cited by the officer who arrived on the scene. The policeman said, you're driving drunk. You're cited for that. It was obvious. This guy had the green. You had the red. You ran a red light. Simple enough, right? What does drunk driver do? He goes on whocanisue.com. He finds an attorney to represent him, and now our client is being sued for over $1 million by the drunk driver who hit him for injuries that the drunk driver sustained in the accident. Yeah, I know. How screwed up is that? So what do you do in situations like that? Shoot the attorney, right? That's what people think. It's a good start, right? Okay, but the problem is that there's nothing out there to prevent that lawsuit from going forwards other than are you willing to settle? It's a big shakedown for our client right now in this particular action. And it's unfortunate. But that's why when we look at these LLCs, I'm telling you that you can protect yourself so you don't have to worry about shakedowns. Because they can shake that tree all they want and nothing's coming out of it. Because my trees are made of boxes. I'm not holding stuff in my own name. So you sue me, and I look at you and I say, hey, bring it on. Give it your best shot. I don't need a high-powered attorney to defend me because if you're successful, you don't collect because I have these boxes set up and they provide me asset protection. And the way it works is as follows. When you put your dinar into a limited liability company, The way we do that right now, before it's been converted to cash, is we ledger it in. So we create an LLC for you, and then there's a Schedule A that is attached to your LLC, which lists all the assets that are owned by your limited liability company. And so on that Schedule A, we list the amount of dinar that you own. And we say, on this day, I transferred the following dinar into this LLC. Now, sometimes people look at me and say, well, Clint, I still hold on to it. I know you're the custodian of it, as am I with my dinar. My dinar have been ledgered over into my LLC, but they're in my safe. That's just the way it is. So my LLC now owns these dinar. So at that point in time, if something were to happen, could they take your dinar from you? If they asked you, if they deposed you, Elena, if I depose you and I ask you, do you own any dinar? What do you say?
No, I don't.
That's right, you do not. Do you own anything?
No. Oh, I own an LLC?
Yeah. Okay, so you say, I own a box. That's not what I wanted to hear, is what the attorney's going to say. Because the box is discouraging to the attorney. Because they know that that box is not something that they can take from you. So when you have it inside of this box, I cannot come up and say, give me your box. And the way your ownership is designated in a box is that you're listed as a member. Members, that means it denotes ownership. You get little certificates that say you're a member in this box. So they can't take these from you. Why? Who says they can't take them from you? Any idea? The law. The legislature, the state legislature states that they cannot take them from you. What they say, not all, this is not uniform by the way, not all legislatures and states have adopted what I'm about to tell you. The states that we like to work with, their law does not give a creditor the right to take your box from you. They do give them a remedy, but it's not a remedy that is palatable from my point of view. Because they say you cannot have this individual's box. You can't tell the individual to sell his box and pay you what he received from it. You can't tell the individual that owns it to reach into his box and pull out the candy and give you the candy. All you can do is tell that individual that if you ever take the candy out of the box, it's going to go to the plaintiff. And that's called a charging order. So if money is ever distributed out of this box to you, and you have a judgment against you, then that money shall go directly to your plaintiff and not to you until that judgment is paid off. Okay? So, let's think about this. I create a box. I'm listed as the member. Now your box needs somebody to run it. We call them managers. So when we've created, thanks, I could probably use more boxes. When we create our box and we need to appoint a manager for that box. Hey Greg, can I get a cup of coffee? Yeah, thanks. So I need to create a manager for my box. Who am I going to appoint as the manager of my box? Nice one. I haven't started drinking yet. Okay, given the fact I'm blonde, you get a few drinks from me, I may make you the manager. What were you going to say? Doug Denarlis. All right, he wants to be the manager. Well, it's your box, Doug. Who are you going to make the manager? You're right, yourself. See, the manager of the box decides if there are going to be any distributions from the box. You with me? Okay. So if any distributions will be made, they're from the manager of the box. So you have a box set up, somebody sues you, and they slap a charging order on your box. And it says that they're entitled to receive any distributions. So one day you go to yourself and you say, Clint, can I have a distribution? Oh, I guess I can't do that. Well, no, Clint, you can't have a distribution because you have a charging order on your box. Okay, don't give me a distribution then. That's how it would play out. Okay, as long as you can have that conversation with yourself, you don't have a split personality that may work against you, this will work for you. Now, what qualifies as a distribution? No, a distribution with a box, you get a checking account. And you pull something out of it, you write yourself out a check, and you don't classify it as anything, that's a distribution. So, there's something now that's floating around that we haven't touched on, and I know there's a question. Well, Ray, we're going there. Ray said build a new box and move the assets in the other box. Not quite there yet. Is anybody wondering about something? You cannot take assets out of the box because it would go to your creditor. Does that worry anybody? Mark? Yes, yes. You look at it and you go, oh, I'm hungry. I want orange candy, Tammy says, but I can't get to it. So we don't take distributions. Okay? What we do instead is we say, Clint, well, you're not going to give me a distribution. Give me a loan. What terms are you going to offer me? How about 10 years, 5%, balloon payment? You going to pay it back? Absolutely. You can trust me. I'm a lawyer. Right? You can do that. It's called a loan. Loans will work. You can take loans. Now, Nick, to put together a loan, is it just you write on the check loan and just take checks every month? Oh, another loan today. How cool is that? No, you don't. Okay, you have to actually put together a promissory note. You have to have commercially reasonable rates of terms built into that, and you have to have the intent to repay it. And then it can be respected as a loan. So you're just not going about your daily life. You have to do some things. But if it's a loan, then it's not considered a distribution, and they cannot go and attach it. Another way to take money out of this box that is not considered a distribution would be to take a management fee. Wow. Well, I mean, if you ask Clint to manage your box for you, I'm not going to do it for free. Why should you manage that box for free? If you're the manager, you shouldn't. So pay yourself a management fee. That's not a distribution. Now this is getting a little complicated here. We might cover this tomorrow, but if that were to happen, if you were ever involved in a lawsuit of that nature and they had a charging order against you, I would create a corporation for you and nestle it right upside your box. Looks nice and pretty as the manager. You'd be working for this little box, and then your little box would charge the big box pieces of candy to manage it. And that would go up to here, and then it would go out to you as a payment and salary. So that's how you could get money out of this box, through a management fee. Yeah?
I have two questions. One is, once you get the money from the box for the fee, then you pay taxes on it at that point, right? As a salary.
Her question is, when I take money out of the box, is that when the taxable event occurs?
Correct.
Okay, no. Taxes happen irrespective of what you pull out of here. If the box makes money, you own the box, you pay tax on whatever's generated inside of here. If it makes no money, you don't pay any tax on it. Distributions that you're taking out are not taxable. We don't pay attention to the distributions. All we pay attention to is how much money was made inside of the box this year. And then you pay tax on it come April 15th. Question I get all the time with the NAR conversion. When do I pay tax on it? When you file your tax return come April 15th. Well, how about if it's in the LLC and I'm pulling money out? Isn't that taxable to me? No. You know this. Let me put it to you a different way. You have a savings account. Your savings account generates for you $100 in interest. When you pay taxes on that money, every time the bank sends you a statement and said, hey, you made $5 this month in interest, do you then have to send Uncle Sam his 25, 35%? No. You pay tax at April 15th when you file your 1040. Now, if you go down to your savings account, you made $100 in savings. Okay, you with me on that? We made $100 in savings this year in interest. If you went to your savings account in November and took out $5,000, do you have to report $5,000 in income on your tax return because you pulled $5,000 out of your savings account? Why not? But you took it out. You already paid taxes on it. It doesn't matter if you took it out or not. It's your money. You already paid taxes on it. The only thing we're concerned about is, did the money inside of the box make any money? So when you're pulling money out of the box, that is not the taxable event. The taxable event occurs at the end of the year when we look at the box as a whole and say, did this box make any taxable income for the year? And if it did, and you own 100% of it, you're liable for 100% of the tax. If Jane and you are partners in the box and she owns 60%, you own 40%, well then she'll pay 60%. 60%, I mean that income would be allocated to her, 40% to you, regardless if you ever took any money out. It just happens.
The other question I wanted to ask you was, I heard you sort of state that different states are handled in a different way.
Hmm?
Now, I'm from Louisiana, and we have...
I'm sorry?
I'm from Louisiana.
No, I said I'm sorry.
We have a lot of fun.
Yeah.
Anyway,
Most of your troubles were washed away not too long ago. And they all went to Texas, I heard.
yeah, we lost
Yeah.
quite a bit in that storm.
Mm-hmm.
But we're under the Napoleonic Code, and so we have different laws there.
Mm-hmm.
It's different than the rest of the nation.
Absolutely.
So
How does it work? Well, I think we can restate her question as follows. She wants to know, where do you set up your LLC to gain the best asset protection? If you live in Louisiana, do you have to create a Louisiana LLC to protect yourself, or are you free to choose where you create your entity? The fact is, you're free to choose where you create your entity. And that's the great part about being in this country. I do not have to set up my LLC in Louisiana and avail myself of their laws if I don't want to. I can choose another jurisdiction. Now, with that being said, you also have to understand that there are certain situations where you do not have an option. When you own rental real estate or you're running an active business, you have to be filed in the state, where you're conducting that business. There's no choice there. But when you have an LLC whose sole responsibility is to hold investment assets, there's no business word running through here, then you're free to choose any state to set up that company in. And when given the choice, I'm going to pick a jurisdiction that puts up a nice impediment to creditors. Now let's talk about your state here. Your laws are fairly good when it comes to asset protection for LLCs. They have what I like to see in them, that the charging order is the sole and exclusive remedy. Does it say sole and exclusive, Greg? Mark, right? Sole and exclusive. Those are key words, sole and exclusive remedy. What it means is that everything I just talked about is the only thing a creditor can get. They can't foreclose on your interest and take it from you. That's what happened in Florida last summer. If you're interested in that, you can research. Type in Clint Coons and Olmstead, O-L-M-S-T-E-A-D. I've written a few articles on it and a video I put together on this decision. Basically what happens, FTC went down to Florida. A guy had some LLCs set up. He argued that the FTC could not take his LLCs from him because charging order protections apply. The Florida Supreme Court made an intellectual leap and said, oh yes, we can. We can take your LLC interest from you. The charging order is not the sole and exclusive remedy because the statute doesn't say sole and exclusive, it does not read sole and exclusive remedy. If it was written similar to Nevada's statute, then we couldn't give it away. But since it doesn't have those words in it, we're free to give it away to the government. Now, the facts of the case are disturbing, and you would say, well, the government should take this individual's money, but you have to separate it. You have to look at it in the whole and say, on the statute, on the face of the allowed, a creditor allowed to take your interest. So in that case they were, but you can see the thinking of the court was that they stated that if it contained specific language, we can't. Now that specific language they drew upon was Nevada's statute. Now, I'm not saying this is why I've always chosen Nevada. I mean, it is a strong reason why, but it's not based upon the Olmstead decision. It's that when we look at things, when we choose a state, we're looking at a number of factors. Number one, we want to see that language in your statute. Is the charging order the sole and exclusive remedy? It states that it is in this state. So if somebody sued you, you had an LLC set up in Kansas, they could not take your LLC from you. So why not just set up a Kansas LLC? You can. I have no problem doing that for clients. I'll set you up one, but if you want some additional protection, then you're going to have to go out of state. So what do I mean by additional protection? Well, there's some other protection that comes with this. See, when you set up an LLC here in Kansas, you have to give them some information. They want to know who the members are, who the manager is of that LLC. So if it's your LLC, then it's your name that's going to be listed with the Secretary of State. So if I want to know what you have going on in your life, all I need to do is go and run a search. Bam, there you are. You've got an LLC. It's called DDRV, okay? I know that it's you then that holds this. So that aspect of it is what we call anonymity. Okay? There's no anonymity there. I can do an asset search from you, and I can figure out what you have. Now, some people don't like other people knowing what they have, especially after the RV. Do you want your local bank to know that you've come into money? Because sometimes people have loose lips and they start telling everybody else in the neighborhood that you come into money. Next thing you know, you got a bunch of friends you never knew you had. So what you do in that situation, you choose another state that has additional protections that will not allow the state to disclose your private information. That's what Nevada and Wyoming offer. You set up an LLC there, you use a nominee manager. So we have one of our attorneys serve as the initial manager in your limited liability company. And then he resigns, and then you get appointed the manager. You're in complete control. You're the member. But if somebody did an asset search from you, this box will never show up as being your box. There's no way they're going to find it's attached to you unless you disclose that information. So that right there is great protection. It discourages people. I mean, how could I put it to you in a different way? Oh. I am a new owner of a cat. Never been a big cat person. I'm a dog person. But we got a cat. It's kind of a cool cat. It's a ragdoll cat. Big cat. Looks like a dog. That's why we got it. Now, this cat, when they're young, and it's the way I grew up, jumps up on the counter. Can't have that. Cats cannot jump on the counter. If it does, what do? Okay, you said squirt it. She says shoo it off. Well, my wife and I have different ways of handling the jump. Okay? I was taught, bam, smack the cat. Falls off the counter. She'll go and squirt, and we have water all over the house from her squirting the cat. Frankly, I'm thinking, hey, there's liability there, water on the floor. Somebody come over, slip on that, slip and fall, and they sue. I'm an attorney. I'm thinking always in liability. So when I was a kid, we had a cat too, and Mouser cat would go down the barn, but it became more of a house cat after a while. My dad would hit that cat, it would fall off the counter. Finally, it never jumped up again. Why is that? Equilibrium was all screwed up. Couldn't jump. No, it didn't happen like that. Sounds good though. No, it doesn't sound good. Anyways, so what people did back then, I remember this. I went to one person's house one time and I sat down on their couch and I'm like, what the heck? There's dust in the air when you sat down. They go, oh, we just got a new cat. And I said, what does it do? Cough dust? You go, oh no, that's to keep the cat off the furniture. I go, what do you mean it keeps the, oh yeah, we got this stuff, maybe it smells like dog or something. And it's just going to be a while. We just sprinkle it on all of our stuff. And the cat comes by and sniffs it. And it won't jump up. We don't have to hit it. We don't have to spray it. Isn't that cool? Yeah, if you're like sitting in dust. So, that's a humane way. And if you think about it, cats sniff. They don't like the smell they leave. You set up a Nevada LLC, it's the same way with attorneys. It's attorney be gone. They come sniffing around. They don't like what they smell because there's nothing for them to get. Does that make sense now? All right. So that's another protection. It's because they can't get it. Now, the third form of protection, which is probably by far even more powerful of a detriment or deterrent than the fact that they can't get the interest, the fact that they don't know you have the interest, but they would if they sued you and they were successful. You would have to disclose this eventually. But think of it. Here we are in Kansas. Attorney sues you and they bring you into the deposition because it's called supplemental proceedings, and now, Nick, I get to find out everything you own. And I'm thinking to myself, payday, wife's getting a new car because we just sued Nick, and I ask you, Nick, what do you own, Nick? What do you say?
Box.
And where's that box located, Nick?
Nevada.
It's located in Nevada. What? Can you repeat that again, Nick? I don't think we got that.
Nevada.
Oh. You have a Nevada box. All right, thank you, Nick. So now I got to go back to my client and tell my client, we've got a problem. Nick put together one of them Nevada boxes. And we're going to have to hire another attorney. How much money you got? That's what he's going to have to ask him. Because you've got a judgment here in Kansas. You've got a Nevada box. It's not registered to do business here because it's not doing business here. If it was registered to do business, we don't have a problem, but we're not going to register it here because it's not doing business here. So now we have to go to Nevada, hire an attorney to go place a charging order on your box. Does that come cheap? No. It's going to come at a cost of probably between $6,000 to $10,000 that the plaintiff's client will have to come up with in order to put that charging order on your box. Now, do they want to go to that trouble? Depends on how much you upset them. You know, if you really upset them, maybe they're willing to do it. That's fine. Let them. Who cares? Because once they go to that trouble to put the charging order on my box, then the game changes. Because I will come up to you. Let's assume that you sued me. And I would say to you, who haven't we picked on yet? Ray. So, Ray, you hired Terry over there to represent you. I mean, he looks like an attorney today. Looking good, Terry, suit and tie. He represented you, and he's a good talker because he convinced my mother-in-law that you deserved 8 pieces of candy. Now, how much you been paid yet, Ray? I know. How's that setting for you? Not too good. I know, that's too bad. Well, I know you're entitled to 8, but I understand you got hurt. And believe me, I don't want to hurt you, Ray. You know, I believe that it's my duty as a citizen to make sure that you're made whole, but I don't think it's my duty as a citizen to make sure that you profit off of my mistakes. Now, Terry over there may think so because he just can't wait to get his little greedy hands on all my candy. That's not going to happen, Ray. So here's what I'm going to do to you. I'm going to offer you 3 pieces of candy in order to settle because I think that's fair based upon the injuries you sustained. What do you say, Ray? Better talk to Terry first. What do you say, Terry? You're entitled to 8 and you get 50% of that. But do you want 4 pieces or 1.5? Yeah, greedy attorney saying, no, hold out. We're going to get it all. Okay, fine. That's fine. I don't talk to you for a year. And I come back to you a year later and I say to you, Ray, how'd that charging order work out for you, Ray? You still talking to Terry? No. I didn't think so. You're right. So, you willing to settle? Are you willing to settle, Ray? Okay, great. Well, what did I, my memory's kind of bad, Ray, being out in the sun and all. What did I offer you last year? 3. That's right, Greg. That's why you got to get better counsel than Terry. So you're right, Ray. 3. That's not how I remember it, but I'll tell you what. Since my memory is not too good and all, and I know I did hurt you, and I want to make you whole because I believe in making you whole, Ray. So I think I'm going to offer you exactly what I did last time. Your injuries make you whole. I'm going to offer you one. Isn't that what I offered you before? Oh, well, that was last year. How much did you get paid again? I know. So now it's 1, Ray. Do you want 1 candy? Okay. My conversation with Ray is now over, and I won't talk to him any longer because I don't need to. That charging order is going to expire. So I'm just going to sit back and wait. Clint needs money. Clint's going to take out a what, Gene? Get money out of the LLC, starts with an L, ends with an N. Loan, that's right. Looking for help over here. Is this your lifeline? Okay. I'm going to take out a loan. No, you couldn't take all out as a full loan, but you could take out a loan. So I'm going to take out a loan. Now, is Ray or Terry going to be fixated on this LLC for 7 years when the charging order expires, getting ready to go back and hire an attorney to go and slap that again on my LLC? Or do you think that they might slip up and forget about it? I think the answer to that is no. And I just know from my own experience, you know, the few liens and stuff that I've filed in the past, you forget about them. And all of a sudden one day, you know, the secretary brings in a check. She goes, "What's this check for? We just got a check for $75,000 something dollars." We did? What do you think I say? Did you tell the partners? If you didn't, there's a third of it for you. No, what has happened is that you filed a lien against somebody in the county where you got the judgment against them, and that lien stays there until they sold a piece of property. And as soon as they've sold a piece of property, that's the first thing that gets paid off after the underlying lien to the bank, and that got sent to our firm. And so part of that's owed to the client, part of that's owed to me, and all of a sudden that's like free money. But you don't remember until the time you get the check. You're like, "Oh, yeah, I remember the Johnson case. All right, finally paid off." Well, I doubt they're going to be following on to this. And so what's going to happen is when your lien expires, or when that charging order expires, what are you going to do? You're going to create a new box. And what are you going to do with this new box? Right, I'm going to take everything out of this box and put it into my new box. Now, what am I going to do with this box? That's right, bait. Yeah, I'm going to wave this in front of Ray's face. You smelling it, Ray? He's like, "Oh, yeah, that box. Terry, get on it. Come on, boy. Get down there and file that." And they're going to run right back down and put the lien on this box. And guess what I got? I got me a FedExer over here that they don't know about. And I can take distributions all day long because there's no charging order because my name doesn't attach to this Nevada one. They just know about that one. And so this will go on and you'll never get paid. And that's the way it works. Now, what I've just described to you is a situation of somebody taking a lawsuit against you with a judgment all the way through to the charging order. How often does this occur? Rarely. This rarely occurs. And as a result of that, when people ask me, "Well, how much case law do you have to back up what you're saying?" Not a lot. Not a lot. And the reason why there's not a lot of case law out there, because attorneys do not typically take it to this level. Number one reason, it's too expensive and too difficult to try to get after the assets. The other thing is you have to go to court and you argue in front of a judge who typically doesn't understand most of the stuff to begin with, and then, you know, you're in a situation where it can go against you real easy. So they tend to shy away from this type of action. And so this immediately, once they find out that you have it, they're going to start talking settlement. And I know that firsthand experience of how this works because I have been involved in a few situations where it's come up with clients. The other side looks at it and you can just see that they're deflated once they find out that these have been set up. Or they know ahead of time that they've been set up because they just figure it based upon who they've been working with, and they start talking settlement. And if they don't, just the cost alone will put them into, well, you could put them into bankruptcy, as we did one time. When I first started the practice, we had an attorney that worked with us. Whenever you go into partnerships with people, there's well, not always, but there's a good likelihood there's going to be one who thinks he's entitled to everything and doesn't have to do anything for it. And when you're so busy working, you're not paying attention to it, but finally one day you start looking at what's going on, you say, hey man, what are you doing? You either put forth more or you're out of here. And they look you in the eye and they say, listen, you don't understand. Okay, I'm just more efficient than you. I can do in 3 hours, it takes you 10 hours to do, and that's why I'm entitled to the same amount of money. Okay, we'll see how that plays out. You're out of here. So we fired a partner, kicked him out of our partnership back in, was it 2000 we kicked that guy out, Greg? 2001. And this is how screwed up the legal system is. We kicked this guy out. We have meeting minutes saying that we've just removed him from the partnership. He's no longer a partner. He went out and immediately, we told him to pack up and get out of the office. He went out and he told several of the employees that we were SOBs, that we just kicked him out of the partnership. And then he was kind enough to send several emails to individuals as well, you know, saying what SOBs we were for kicking him out of the partnership. Now, 1 year later, he comes to us, he asks us for money. I said, no, you're not getting any money. We actually gave him some money when we kicked him out. So you're not getting any more. So he went and hired an attorney, and they filed a lawsuit against us. And they said they stated in their lawsuit that he was still a partner. Like, you got to be kidding me. You're still a partner? No. So I went into court, and we tried to get the judge to take what's called judicial notice of the fact that this individual was no longer a partner, and we brought into court sworn affidavits from the 9 people that he told on the day in question that he was kicked out, that he went out to him and he told him that he was just been removed as a partner and he hated us for it and blah, blah, blah. They had their own sworn statements that he'd talked to. We brought in copies of his emails where he'd sent to people. We got from the individuals. So it wasn't from our system. We got it from the individuals. And we brought in our meeting minute notes. We say, Your Honor, let's just dispense with this right now. Would you take judicial notice of this? You know what the judge said? That's a question for the jury. I tell you, that's when I lost all faith in the legal system. Right at that point, well, I was questioning it beforehand, but right then and there I just said, you got to be kidding me. What do we need to do in order to dispense with this type of legal process? Basically spend money on attorneys. So that became who can spend more. Well, we spent more. We forced him to go down to Las Vegas and fight the action. He tried to come after us. We got it removed to that jurisdiction, and right then and there, we forced him into involuntary bankruptcy because he ran out of money and he owed people. So we brought that action against him, and that wound up the case. So there's tactical maneuvers that take place when you create these entities and move them to other jurisdictions that work in your favor. And that's why I believe if you're looking to protect liquid types of investments, your dinar, cash, gold, stick it in a jurisdiction that's out of reach. Don't make it easy for somebody to harass you with a lawsuit. Make it difficult. And build your barriers. And that's what that would do. And that's why I recommend people create them in Nevada for those 3 reasons that I just laid out for you. Any questions on that? Yeah.
What are the requirements for example, establishing an LLC in Nevada for the very purpose of holding these liquid assets?
What are the requirements for establishing an LLC in Nevada for holding these liquid assets? Really, I mean, you have to have a resident agent. That's it. A name. Nothing more than that. Now, I mean, we tell you you should have a business address there, so you have a physical presence, phone number. You should use a nominee, somebody who serves, so that if somebody looks your name up, you're not going to be attached to it. Take advantage of that. I would recommend you have a bank account. So whenever we set up a Nevada LLC for our clients, we give them a choice. They can either bank with Chase, Wells Fargo, or Bank of America. We will open that account for you. Well, let me rephrase how that works. What we do is we contact the bank and we say we have a client. We have a banking relationship with these 3 banks, so our clients do not have to physically go to the branch to open their account. we just tell them, we're working with this client, we've established a business with them. They would like to utilize your services for their Nevada bank account. Here's their contact information. At that point, we step back. We're no longer involved in the process. They will contact you directly, and then you'll work with them to open your account up. They'll send you the signature card and back and forth. So you should have a bank account there as well, is what you would do. And that goes, I mean, you're going to want that anyways, because when your dinar is placed inside of the LLC, and when it RVs, you go down to cash it in, you want those funds to go directly into the LLC. And if the LLC isn't in place and the bank account isn't there, it's going to go into your personal account at that point in time. So that's why it's so important you have that account opened up ahead of the RV. Yeah, do you have a question? There's another question over here? Yeah. That's an excellent question. The question was, do you have to file taxes in that state? And the answer to that is no, you do not. Nevada does not tax its entities. The only way you have, well, I misstated there. Nevada has a state tax. It only applies if you live in that state and you have employees. You do not live there as a business owner, you do not have employees, therefore you do not pay tax. The LLC itself does not pay tax. When you create the LLC, you have two choices. You can create it as a single member disregarded entity. So Greg, in your situation, if you're going to create it as a single member disregarded entity, that would file a federal tax return. It means it only has one owner. That one owner would be Lisa. If you think I'm joking? Yeah, if you want to have husband and wife both owning the LLC, because you do not live in a community property state, it would have to be set up as a partnership. Now again, it doesn't have to file it has to file a tax return, but the LLC does not pay any taxes. It's purely a flow-through entity. It flows down onto your individual 1040. So it's tax neutral. We get a lot of questions on this. People ask us, how is this going to impact my overall tax situation? It will not. Zero, one way or the other, not to the negative nor to the positive in creating this entity. This entity is purely for asset protection to mask the fact that you've just come into some cash and to protect it. That's why you've set it up. Yeah. Question?
So what would be the difference in doing it pre-exchange, post-exchange, putting it into this LLC?
Great question. What's the difference between doing it pre-exchange, post-exchange? Pre-exchange, your box is set up, it's already done. When you go to, if you're involved in something were to happen to you right now, it's all protected. Nobody can get after it, number one. Number two, when you go to exchange in your dinar, you have an account, you have an LLC that's already set up. On the RV day, money goes right into there. It's all done for you. If you wait till post-exchange, what's going to happen is you have to go through the process of setting this up. How long does it take typically to set up an LLC in Nevada? It will run, on average, it takes us about 2 weeks. Now, that's not to set up the LLC. What takes the longest is getting the bank account established. That's what takes the time for the client, is to get their bank account up and running with their LLC. So the LLC I can set up relatively quickly in a couple days. It would be in your hands for signature, but it's the bank account. Getting that set up takes the time. So that's why people have opted to set it up, number one, the LLC, is so that the funds will go directly over into it. Otherwise, it'll have to go into your own name. Another reason why people have opted to set this up. When you set up an LLC, you're the manager, right? Managers control the LLC. Managers make all decisions about who's going to get candy out of the LLC. So, if we set up an LLC and I have Bonnie as one of my members, and is it Steph? Kathleen as the other member, and I give Kathleen 30%, Bonnie 30%, and I have 40%. And I have my LLC set up where it requires 85% of the members, 1, 2, 3, to agree to replace the manager. Now, who's the manager? Clint. So in order to replace me, who has to agree? Yeah. Am I ever going to agree to replace myself? No, never. Now, My LLC is set up where they're not entitled to distributions. You don't get any money out of here unless Clint decides you get money. Clint could do this. Clint gets money. What do you guys get? Nothing. Okay? How do you like them apples? So, you set this up, you also have some control. I would have control over Kathleen and Bonnie. This RVs, and I have $1 million in here in income. How much is taxable to Clint? I have 40%. 40% of $1 million is $400,000. $300,000 to you, Bonnie. $300,000 to you, Kathleen. It's a flow-through entity. You own 30%. You're responsible for 30% of the income that's generated inside of here. Now, all of a sudden, you've just made $300,000. How much of that can you touch and feel and spend? Nothing. Now, do you have to pay taxes on that money? You bet you do. But you don't have it, do you? What a dilemma. We've got a problem here. Now, could I decide to give you money if I was in a generous spirit? Absolutely. But if you upset me, yeah, so I'd say, Kathleen, you want a distribution? Yeah, Clint, I got to, I'm looking, averaging this out. I'm going to pay $90,000 in income taxes. Okay, well, see my car out there? It could really do with a good wash and wax. What you doing tomorrow? Could I do that to her? Absolutely. So the question is, do you want $90,000 or you want to wash and wax my car first? Now, I'll come right to you, Norma. I wouldn't do this initially, but I wouldn't do it with them, but think about your children. Okay, you do this with your kids. You gift this interest pre-dinar so it doesn't cost you anything for gift tax purposes, and now you've owned them for life. Yeah. See, when I was going to law school, my dad played this game with me all the time. Hey, what are you doing today? This is during the summer. I get these calls at 5 a.m. I didn't know it was light out yet. Is it day? Really? It's day over in Bremerton? Because it's not day over in Federal Way yet. I'm looking outside. Gosh, it's funny how the sun came up today, Dad. He goes, it's day somewhere. And I tell you what, we're going to re-roof a house today. Did I hear you say we? I think I got a bad connection on the phone. You heard me right. We are re-roofing the house on Callow. I don't know if I can make that, Dad. That's what I would hear. Silence. You still there? Uh-huh. What you doing? Calculating. What are you calculating, Dad? When you go back to school? 6 weeks? He goes, all right, that's 30 days. No, it's 42 days. And how much is law school? Well, you cut the check. It's $22,000. I know that. So 42 days into $22,000. I figured then you're going to need to make about $500 a day between now and law school. If I don't see you use some expletives there, in about 45 minutes to help me re-roof the house. What is it? You're going to help me, or are you going to go out and start working? How about if I get there in 30 minutes? Will I get a bonus? See, he had me. He had me. You'll always have your kids, because if they don't come over and visit enough, there's a tax liability this year and we didn't see ya. There's no money for you. Yeah, that's the power. And so people have said they wanted to gift in our way. I said, through an LLC, gift them it, and it's a disguised gift. They may be happy today, but next year when they got to pay taxes, different story. Because you don't have to distribute money to them. Because your agreement states that they're not entitled to receive a distribution. All distributions are left up to the discretion of the manager of the LLC. Nora, your question. Well, you bring your LLC operating agreement down with all your schedules to show that you transferred it over to the LLC on the date in which we specified. I provide it all. That's right. And if you need to, we'll provide you a certification that you'll have notarized. So it would protect them. The certification is actually already written into your management or your LLC operating agreement, and it states that you as a manager certified of the following, blah, blah, blah. This is what you'd provide them. And that's sufficient in order for that to occur. Any provision for the death of the manager. Yes, the members would then agree to appoint a new manager at that point in time. The remaining members, yes. The child in the LLC would be referred to as a member because they own an interest in it. So, I mean, I've had a lot of, just one I was working with yesterday, or this week. He sent me over. This guy actually bought his in theater. He was in the Army, and he was over there on tour, and he bought his for $700 per million. And he was telling me, and I go, well, what got you interested? He said, well, because of not all my buddies. He had a few guys that were over there during Kuwait, and they were invested in the Kuwaiti dinar. Yeah, they made a lot of money. And so they, of course, got out of the military as soon as they could, and they're not working. They're doing other things. And he said, this opportunity's not going to pass me by. And he sent over his dinar, the amount of dinar that he had, and let's just pick a round number. He said 10 million. And he told me that he wants both of his daughters to each own 15%. So what I have done is I've put together an LLC where he and his wife each own 50% of the LLC. So each of them transferred in 5 million dinar. They signed the agreement, all done. And then I prepared a gift of their interest. So I gifted 15% from him to one of his daughters, and I gifted 15% from his wife to the other daughter. So each of them received 1.5 million dinar, each daughter did. And then we had them sign the assignment and admitted them as a member to the limited liability company. So there's another form they had to sign where the membership agreed to admit the daughters as new members to the LLC. And they received, each of them received that 15% ownership interest. So now all 4 of them are in the LLC, but the mom and dad are the ones that are in control of that LLC. And daughters, of course, own it. Now if they're minor daughters, minor children, which these 2 are, when we gift it to the guardian of the daughter. So when I gift from the mother to the one daughter, I gifted it to the daughter in care of the husband as a natural guardian for the minor child. So when you gift to a minor child, you have to gift it to a guardian in care of them. So that's how we had to gift the interest over. If they're already of age of 18 years older, then we can gift it to them directly. We don't need to go that route. But if they're a minor, then we have to go a little different route to get it to them. And then they become members of the LLC. So at that point on, when it RVs, they're responsible for 15% of the income that's generated inside of there. And of course, you would give them a distribution to pay their tax liability at that point in time. So that's how the LLC works. Any questions on that? It's all about money.
You don't want them to have it at 18.
You don't want them to have it at 18. That's exactly right. All right. Greg asked, can a LLC be controlled by the manager without reporting to a board? Absolutely. That's how they're set up by default. If you want us to create management committees, we can complicate it for you. I would recommend we do not, but that's what I would do. All right, so how do you want to be perceived in a lawsuit? Okay, this is Doug over here. Doug owns everything in his own name. He carries it around in a rubber band. Okay? There's Greg. All right, Greg's inside of a box. So obviously, it's pretty clear what would happen there. Okay, keeping your own name, there's really no protection. Oh, yeah. All right, step 2, control over your taxes. Which way do you want to go? What are our options here? I get this question a lot. Clint, you're going to be swamped on the day at RVs. I'm going to be calling you right away. So you go right ahead and call me. You're not going to get a hold of me. I won't be answering my cell phone either. Once at RVs, I'm running right down to the bank and I am cashing everything in that I have right away. I'm not holding on to a dinar one. Why? Because it's currency. Currency tends to fluctuate. And it could go up, it could just go down as well. I'm just going to throw all my chips on the table and cash in because I'm going to get a great return. I mean, you bought it for a fraction of a cent. And even if it came out at 25 cents, I mean, that's a huge return right there, and I'll be happy with that. So after I cash it in, all of that money, of course, is taxable to me. But I get this question 90% of the time. How do I avoid paying taxes when it revalues? Okay? Well, you understand that there's no way to avoid taxes unless you give the dinar to a charity. If you take the dinar and cash it in your own name, it's taxable to you. Then you turn around and you give that income to your charity, your tithe. That is a tax deduction for you. But you first pay tax on that income you received upon the trade-in, and then you get a tax deduction for whatever you contribute. And the way the tax deduction works is you can write off up to 50% of your income for charitable contributions. 50% is the max. The problem with that is you have to pay tax on it. So if you have if it's you're planning to gift away to charity some of your newfound wealth, my response to that would be to give them the actual dinar and instruct your pastor, whoever you're giving it to go down and trade it in themselves. Because they're a tax-exempt entity. They will not have to pay taxes on that conversion, and that way they will receive more overall wealth in that manner. So if you gave them, $1 million dinar and it came out at $2, you just gave them $2 million. But if your intent was just to take this $1 million dinar and give it to them and you go down and you cash it in, well, you better set aside some for taxes. And so it'll be something less than the $2 million that you want to give them because you have to pay income tax on it first. So that's how I would address that. Now, the other option you have is with charitable remainder trust. And this gets Greg's going to go into this in detail tomorrow, but that's the second option we have up here. And people often ask me, when do I set this up? The answer to that is after the RV. Can't even consider it for you right now. The reason we can't consider it because we don't know what it's going to come out at, we don't know when it's going to RV, and I have to crunch numbers that are based upon your age, the date you're going to make the contribution, and the current AFR rate that's put out by the government for that month, or I can go back 2 months. So these all determine what your payout is from this CRT, and that's going to be covered in more detail tomorrow. But what is the CRT? It's another box, but it's a little different box. If you take your dinar and you cash them in your own name, you're going to pay tax on this money. And then when you take and you contribute it into this charitable remainder trust, you're going to receive a tax deduction. Okay, but I had to pay tax first and then I get a tax deduction. So the net effect is the IRS benefits. If you want to make sure that you benefit, what you need to do is take your dinar, do not cash it in, but put it directly into your charitable remainder trust that you've created after it RVs, and then cash it in. Now when you cash it in into the name of the box. It's cashed in the name of the CRT, so the income then is attributed to this box. The CRT does not pay tax on the money it receives.
What's the CRT?
Charitable Remainder Trust. Now what does that mean? That when you and your wife pass away, then whatever's left inside of this box will go to a charity. It's distributed out to the charity of your choosing. Many charities you want. Or you can turn it into a private foundation. Your kids can run it for their lives and your future generations. Lots of things we can do with that. We'll cover it tomorrow. But it's a great tool because anything that's generated inside of here is not taxed inside of here. The only time it gets taxed is when you take the money out of the box. That is when it pays money out to you. That's when it's going to be taxed to you. And it's taxed to you based upon how it was earned inside of the box. Do you know what municipal bonds are? Municipal bonds, munis, you ever heard of that term? Okay, they're issued by state governments or municipalities actually is who issue them to raise money for certain projects. They want to put in some water system or something like that, so they issue these munis. Now, in order to entice people to help out the municipality to fund this project, the interest you receive from munis, return you get on your investment there, is tax-free. Now, it's not a huge return typically. They offer a lower return, but in order to entice you to give them the money, they say that the money you receive is tax-free. So if my charitable remainder trust invested in nothing but municipal bonds, munis, then the income I pulled out of it would be tax-free to me, because that's how it was earned inside of here, therefore it's tax-free to me when I get it. So if I converted my dinar into cash, there's no tax because it's in the CRT, and then I take that cash and I put it into stock in Apple, because I'm expecting them to come out with iPad 3 by the end of the year, and their stock's going to continue to climb, and I hold on to it for a year and I sell all this stock. I've held the stock for a year, and then I take out a distribution. How is it taxed to me? Ordinary income, short-term gains, long-term capital gains are not taxed. Any ideas? Long-term capital gains, because I held the stock for a year. So that's how the CRT works. Now, the question that people often ask me is, do I need a CRT? Or, no, actually, I don't tell you, that's not a question. More of it's a statement. I need a CRT. And I said, convince me. Well, I have 8 million dinar. I want to put a portion of that into the CRT and not pay tax. Do you really? How do you know? Because you don't know. You've got 8 million dinar. If it came out at $8, would you want to put some into a CRT? I know. Just play with me, would you? 64 million, right? How much can you spend? Nick's going, all of it in about a year. Sorry. Just had to play with you a little bit there. You say 64 million. Yeah, I'm going to use a CRT. I don't need all that money right away. But what happens if it comes out at 50 cents? Now, is a CRT something you're even going to consider if you only have $4 million? Or do you want that money to go out and buy a new house, pay off some debt, make things easier? So this CRT is something that we look at after the RV. We determine what is the RV rate, and then I'm going to ask you, how much do you want to live on? Because you should not put all of your money into the CRT and use that as your sole source of income. I would discourage you from that. So I tell people, you figure out what that number is that's going to make your life comfortable for you. That should remain in your name. That should stay in the LLC, remain in your name. Anything above that, we can deal with. But I've run into individuals before who have made the mistake. It wasn't through our firm. They've worked with other people, any of their assets into the CRT. And then there's some things that happen in their life that they lose some assets, and then they want to go into the CRT and reach in and claw out a huge chunk of coin out of there. You can't do it. You cannot do that. You're stuck once you start going down this road. So keep a good portion of those assets outside. So the way it would work is as follows. You start off pre-dinar with all your money in your box, dinar in your box. After the RV, you cash in as much as you want. So if it came out at $8, Janice says, well, I'm going to keep $30 million for us. You figure after taxes, you have, depending on the tax rate there, you could have between $5 million or hopefully more left over. And then I'm going to take, let's just say, maybe we're taxing a lot. You would have more than that. You'd have about 20 million. I'm going to take the other dinar, I'm going to put it in the CRT and then cash it in here. So now I have two different pools of money. 20 million here, 30 million over here inside of the CRT. That would work. So in order to do that, you would pull the dinar directly out of the LLC and place it inside of that box. And again, that's all done by the pen and paper is how we ledger that across. So it should all rest in here. Even if you're contemplating using a CRT, you should have everything sitting inside of your LLC until the RV date, And then we'll talk about this other entity right here. But I get a lot of questions on it. And I keep telling people, I understand, I appreciate the questions. You need to understand, understand how it works. But really, put this at the back of your mind. This isn't something that you should be focused on at this point in time because there's too many variables at play in order to jump right into this box. Now, another way to go is with the 501c3, which is a foundation or a public charity that you want to create. Now, the difference here is that if you go down that road, it's not like the CRT. The CRT is designed to pay you out an income stream for life. If you go to the charitable route, then you're not getting paid. It's all about utilizing your funds for a charity. And so you can do that, but what I would focus on is a foundation rather than a charity. They're much easier to create, they're less expensive for you, and they're easier to run. With a private foundation, a support organization, you just have to pay out 5% of your assets each year to various charities. But all the money that you have inside of your box, your foundation, you can invest it, you can grow it, and it's not going to be taxed, and you just have to give out 5% a year. And then when you pass on, your kids can take over the foundation, or they can take over while you're alive and start running it, but you just have to give out 5% a year. It's real simple. If you want to go the other route, where you want to be the one out there deciding who gets money, well, I can tell you this, that it's going to be a longer road to hoe to get you that foundation status. Because when we create a foundation, what we do is we file for a nonprofit corporation with your state. I wouldn't go to Nevada, I would just file right here in Kansas. And it takes me a week. You have a nonprofit all set up, ready to go. You have provisional status for 14 months. I believe it's 14 or 16, I forget the exact number. 14 months, let's say, provisional status with the Internal Revenue Service, where I have to obtain for you a determination letter to get, or exemption letter is what it's called, from the IRS. So I have to fill out an application for exempt status. We've been putting these charitable foundations and 501c3s together for probably 12, 13 years. And in the last 4 years, there's been a shift in the IRS's review process of foundations, or 501c3s. I used to be able to get my determination letter, exemption letter, I keep saying determination, exemption letter in approximately 2 to 3 months after submitting my 1023 application. Now, we're talking 11 months to a year before I'll receive my determination letter. Exemption letter, thanks. And the reason being is that the IRS is scrutinizing now foundations and 501c3 organizations. A foundation's a little quicker, but the 501c3, where you want to be in charge of distributing the money to individuals, that is a huge can of worms that you're going to open up. And you have to be, if you're going to go down this road and that's something you want to do, I'm going to tell you what you need to be thinking about right now. So when you contact me to have me set it up, we've got the ball rolling. You have to be thinking about what your charitable motivation is. Thinking about putting together a statement of your purpose. You're going to have to put together a non-discrimination policy, parameters for giving money out to people. And you're going to have to explain how your organization meets a defined charitable purpose. What is the criteria under which people may obtain money from your charity? How are you going to market? How are you going to fundraise? What is going to be your anticipated budget for 10 years to run this foundation? This charity. It's a long, drawn-out process. Well, not long, drawn-out process, it is, but the application packet is typically about 30 pages in length in order to obtain it. Because they're very concerned that individuals apply for these organizations and they utilize it as a means to line their own pockets tax-free. They do not want you going into competing with businesses. Okay, that's a problem right there. What's on the news right now? I don't know if you caught the Wall Street Journal. There's a charity or nonprofit organization right now that is coming under scrutiny. 3 letters, NPR, right? What are they in trouble for? For being a partisan political organization, that they only promote one point of view. It's like Fox News claiming they're a charity. Okay? Would anybody buy that? No, they'd say no. Fox News, they always blame Fox and saying, oh, they're to the right. Well, that's because you've been looking at everything else that's so far to the left. Any other point of view is going to be considered to the right of that. The thing is that you cannot operate in that manner. You have to be unbiased. So the charity is an alternative way to go, but again, that is something down the road, post-RV. You can always set one up and contribute cash to it as well, and then you would receive a charitable deduction for that. Okay. So we find other ways to do it, and those are through those things. Now, again, I talked about this. How much would you like to save? Really, that's a question afterwards when we figure out what the RV amount's going to be. So the first thing you should be focused on is a limited liability company to protect your dinar. You have an account set up so it's post-RV. Money can roll right into it. You also have the ability, if you plan to gift anything to your children, you have a mechanism by which to do that where you maintain control over those funds. And it's pass-through entity. There are no trust tax rates that apply to it. I've talked to other people about creating complex trusts for children. I would not do that because if you create a trust, non-grantor trust for somebody, the tax rate on a non-grantor trust starts at 35% after $10,000 in earnings, or $11,000, forget which one it is. You're automatically up there. If you make $10,000 as an individual, your tax rate is less than 15%. You don't even actually pay tax on the first $49,000, $45,000 in earnings in this country. So the thing is that I would not go that route if you are considering saving on taxes. I would utilize the limited liability company. Okay. Now, I've got about probably 25, 30 more minutes left to go today. Do you need a break? Are we okay? Can we just roll right on through? Just roll right on through? All right. So the third step in planning is how do we protect our family? And this is to ensure that everything is going to go the right way. I started to talk about this earlier. It's about making sure that this investment, be it pre-RV or post-RV, gets to our loved ones in a manner in which they can handle it. Now, when you have a will to start talking about, you've really turned over control to other people. You've turned over control to an executor, and you've turned over control to an attorney to handle your estate. Now, I personally have a lot of problems with that because once it's out of your control, who knows what they're going to do? They could drag it out like my uncle for almost 5 years and continue to bill. If I was in charge, or if I was an attorney entitled to bill, I would have probably earned about $45,000 in billable fees, minimum, for dealing with my uncle, if I was charging that estate. Because there's no safeguards in place when you put together a will. You have to go through probate. Somebody asked me on break, they said, well, do I have to go through probate if I don't have a will? Absolutely. When you pass away, you have assets. The only way you can move titleable assets from your name to your beneficiaries, if you haven't done so by contract, say joint tenancies with right of survivorship or some other means payable on death, you would have to go to probate court, receive letters of testamentary, and then the bank would be willing to deal with you or your executor. Then the county would allow you to transfer title to your children. The question is, how do you want the kids to have all the assets at age 18, 22, 25? Do you want to leave it in such a manner in which their spouse could claim part of those assets? If they're involved in a lawsuit at that time, you pass away, here they go. They just inherited $3 million. What do you think the plaintiff's going to do at that point in time? Fire it up. Let's light the double burners on this lawsuit because we know they have money now. They just inherited it. We found that out because with a will, it's all public record. Wills, in my mind, destroy family units regardless of the amount of money you have. I hear this all the time from people who told me that they went to their attorney and their attorney told them they do not need a living trust. All they need is a will right now, that they haven't made enough yet. Haven't made enough. That's arrogance. I'll put it to you in a different perspective. How would you feel? Most of the time we look at that and go, oh, well, he's an attorney. He knows, so I'm going to take his advice. But how about if it wasn't the attorney? You ask ADT security guy to come out to your house to install a security system. He comes out with 2 toolboxes, starts walking around your house, shaking the windows, looking around your house, starts walking out the door carrying both boxes. You're like, hey, partner, where are you going? He goes, I just looked around your house. Why don't you call me when you have something to protect, but you don't need my help. How would that make you feel? Isn't that what the attorney's telling you? No, you don't need a living trust. You don't need anything to protect you. Don't worry. When you die, I'll protect you. Oh, yeah. You want to say something?
Well, I just thought I'd point out something for your campus residents. When I came to campus and started law practice, one of the attorneys I first met said, you know what I would do to keep your practice going? Find every old lady you can and give her a free trust, a free will. Because that way you get the probate when she dies.
Lost leaders. That's right.
So I consider that malpractice.
Oh, yeah. Remember that I said I worked for prosecutors, these gals that moonlighted? Here's my first taste into this. Well, second taste. I'll tell you the first taste in a minute. Second taste about probate. One day at lunch, they were sitting there discussing how an elderly gentleman came in on Saturday. They drafted a will for him. They're figuring out the value of his estate. They figured his life expectancy was 1.5 years, and they're calculating that they would earn $40,000 to $60,000 in handling his probate. And they're joking about how they're going to spend the money. That's serious. When my grandfather, who was an attorney for 50 years, he set it up awesome. See, he was a marketer. You would come into his office. He wouldn't give you a free will, by the way. He would charge you. But then he would do something that made you feel special. He'd say, Sherry, I want to show you something. You see over there along that wall, those black fire-safe file cabinets? I bought those for you. Well, not you, but I bought them for my clients because I really care about my clients that I've created estate plans for, because this is probably one of the biggest decisions they're ever going to make in their lifetime. And this document needs to be protected. And what I want to do for you, because you're such a good client of mine, I've gotten to know you, Sherry, is I want to ensure that your document is protected. Because I know when you leave here, you may move in 1 year or 2, things can happen in your life, and you could lose that. You spent all this time putting together this beautiful estate plan to ensure that your loved ones are taken care of. We don't want to risk it to chance. So let me do this for you, Sherry. Okay? Out of kindness and goodness of my heart, I'm going to put your will over there in that fire-safe file cabinet where we could have an earthquake, this building can burn down, and your document will always be protected for your children. You have nothing to worry about. I'm going to give you a copy. You'll know exactly what your will says. They know they can come back to me at any time, and I can gift them the original will. So I'm going to take care of that, and I don't charge. That's one of the added benefits of working with the law offices of Clint Coons. This is a service that we provide as gratis to our clients. And a lot of other people may charge you for that, but not us. Take it. Ching! Yeah, absolutely. Because when my grandfather retired, he looked at his associate and he said, you see all those black firecase file cabinets over there? Guess what? There's gold in them there file cabinets. And I'll tell you what I'm going to do. I'm going to sell it to you at 50% off. And that's how he sold his practice. Because when you pass away, your loved ones, guess where they have to go to get the original will to enter into probate? Law offices of Clint Coons. That's my grandfather. So they go down there, and they come in, and my grandfather says, oh, yeah, your mother was a sweet person. I feel tremendous sadness for your loss. Now, come on into my office. I'll go get the original will, you know. Jenny, will you get me that original will for Sherry? And bring it in. We sit down. Now, this is what we're going to have to do. Right then and there, you're mine. You will not leave there without signing on the dotted line, asking me to represent you in that probate. attorneys use this as a loss leader, as he stated. They use it as a retirement program. I firmly detest the use of wills because the fact it requires the use of an attorney when you pass away in order to pass your estate on. And I have this argument probably once a year. My wife tells me to stop doing it, or I'm going to lose my friend. It's James Jake Potek. He's an attorney in Gig Harbor. We do a lot with that family. But she goes, you're going to lose him. Because I always challenge him on it. I go, now why can't you create wills for people? Why don't you set them up in living trusts? And he'll give me some excuse. He said, it sounds to me like you just want to make sure you get the probate. Well, really, they need to have somebody make sure this and that. And I go, why? Are they that stupid? You only take on people who don't understand how to pass on assets to other people? Is that who you're working with? No, I didn't say that. Well, it sure sounds like it from my point of view that they can't handle it on their own and they need you. Is that what you tell them when you bring them in, that there's no way you could ever do this on your own? It's got to be me handling it. I bet that discussion never comes up. Do you tell your clients ahead of time that when they die with that will that you're going to probate it and you're going to charge their estate to do it? Does that come up? No, that's to the elephant that's in the room that nobody's looking at or you're just trying to hide. Why not tell them, give them the option, hey, you could create a document where you would never have to see me again. You could pass on all your affairs, all your assets without the use of the court system, and it would be private. Nobody would know what you had and who received what, and we can ensure that if they aren't ready for it yet, they don't get it. How does that sound? I think most people would say that sounds pretty darn good. But the fact is, we don't get that information. And we go the same route that we've been taught by our parents, is we create a will when we think we have the estate at the right point in time, and a lot of times that never occurs. We don't see where it happens. We miss the opportunity. I know when my mother's father passed away, my grandfather, she was only 10 years old, but they had this prime waterfront on the Hood Canal, sandy beach. It was a fishing resort, and he had 3 daughters left, each of them one lot. And then my grandmother got everything else. Well, as life would turn, my aunt decided to move back in with my grandmother when I was, probably about 8 or 7. And she moved back in with my grandmother to help her and her husband. Help her do what? Spend her money is what she did. And she started selling off all my grandmother's property. And so my dad, who's a very, as I said, strong-willed person, told my mom, you see what your sister is doing to your mother? She is going to leave her penniless if this goes on. You need to tell your mother to kick her out and stop this before it gets out of control. Well, my mom shies away from conflict. And she sat back and she tried to bring it up, but my grandmother didn't believe it, and so she just stopped. Well, everything went on like this for a couple of years, and finally what my aunt did, she sold my mother's lot. Yeah, she sold my mother's lot. This was left to my mom in a will. My grandmother was supposedly in control of it. There was no trust set up for my mother, so she sold my mother's lot. And what did my mother have to do then? She sued. Now, do you sue the aunt who sold it, or do you sue your mother who was in control of it? You sue your mother. Now, she sued her mother not for the money, and it was a good piece of money, waterfront property like that, is because she thought that by bringing this case that it would wake her mother up as to what was going on under her own roof. I mean, everybody else saw it. RVs being purchased, garages being created off my grandmother's house. My grandmother didn't know how to drive, never owned a car. But, houses being remodeled that my grandmother lived in for my aunt and her husband. And as a result of that, it galvanized my aunt and my grandmother and my mother's other sister against us. And the money, I remember when they got the judgment, my grandfather represented my family, of course, and after he took his fee, he didn't work for free, for sure. My mom told my dad, she goes, I don't want to see this money. I don't want anything to do with this money. I did not do it for this. I don't care what you do with it. Burn it for all I care. Because I remember that conversation. Because I was a little kid. You're like, burn money? I'll buy a comic book. Toys, Army men. So I didn't see my grandmother from the ages of 12 or so or 10. It seemed like a long time. Might have been younger than that until I was 16 years of age. And my grandmother showed up on our steps. A cab dropped her off, and she's there with 2 suitcases. She moved out of her own house because she finally realized what was going on. And this was all left up to this will, which did not provide any controls that nobody could walk in as they did, gain control over my grandmother, then take control of the estate and start dispersing assets as they saw fit under the guise of being controlling the assets on behalf of my grandmother. And what made it actually even worse than that, here she is, moved out of her own house, dropped off by a cab. I see her for one day. She goes to live with my other aunt, not the one that moved in there, who had already separated herself from the family, saw my mom's point of view and what was going on. She finally woke up. She went to live with her. She passed away within 2 weeks. Yep. So all my memories of my maternal grandmother are from film. My mom's shocked, but I just don't remember, other than what I see in pictures. I mean, I go, I remember this, but then I know there's a picture to go along with it. So I lost out on all that, and I blame the attorneys, the people who created that estate. They could have done a better job, and it affected my family and my life as a result of it. So the way you get around this type of stuff, say, I'm not going to leave it to an attorney. I'm not going to leave it to the legal system to decide what's going to happen when I pass away. I'm going to put together a living trust, which is a set of instructions that's going to govern all this. And it does. You can specify, tie it down. I'll give you an example of that. One day, in my office, middle of the afternoon, in walks this nice-looking elderly lady, comes into the office. She goes, I need to speak to Mr. Coons about creating an estate plan. And so my secretary said, well, typically we schedule appointments for him. It's going to be quick. So she comes and gets me. She goes, hey, there's a nice older lady out there, says it's going to be quick. She needs to talk to you. And I went out there. And I said, yeah, hi, my name's Clint. She goes, I've heard about you. I need a living trust. I said, okay, well, do you want to set up time? She goes, no, this is going to be quick. Be the fastest, I don't know if she called me Sonny or what, money you ever made in creating this plan. It's going to be easy for you. Okay. Well, what do you want to do? She says, simple. I want everything to go to my kids outright. Like, okay, that's pretty simple. She goes, but. And I looked at her and go, really? And she goes, I know, you probably think I'm going to give you something crazy now, and you have to start writing, but it's not. It's real simple here. Everything goes to my kids, but $6 million, that goes to my husband, provided he remarries within 6 months of my death. I said, why do you want that? She goes, simple. You don't understand. Ask your wife. I want somebody to be sorry that I'm gone. That really didn't happen. That's just a joke. But it gives you the idea that you can do with an estate plan anything you want, because it's a box, a different box, that your LLC will go into, that your personal residence will go into. You put all this stuff into this big box we call your living trust. It owns everything. So you go through life with this box. And your box has a set of instructions on it that when you pass away, the following individuals are going to be entitled to the assets inside of this box. Typically, everything goes to the wife or the husband. And then when they're gone, then it's going to go to the kids, but it's going to go to them in a certain manner. What's happening there?
What box is that?
This is the living trust now. Okay. This is the LLC. I changed them on you. Okay? Now, yeah, got to get that. So they're all in here, and it's got a set of instructions. So, for kids, you don't want to give them assets outright. Look at my roommate when I was in college, my fraternity roommate, his dad passed away the year we went to college, and they owned a lumber company. And Bill did not get the shares to the lumber company right away. He didn't get it until he turned 30 years of age, but the trustee had a set of instructions that said, or we read it, it stated that Bill is entitled to 50% of all my assets. His younger brother, I forget his younger brother's name, is entitled to the other 50%. But they're not going to receive these shares and the money that goes along with them until they reach 30 years of age. Until that time, my trustee is to use these funds to ensure that Bill and his brother each get through college and get a college degree. They're supposed to pay for their college. They can buy him a car, which the trustee did buy Bill a car. And it wasn't a new car, it wasn't a fancy car, it was an older Subaru. It was a reasonable car. We were at WSU, Snow over there, four-wheel drive car. That's what Bill got. And he didn't get a bunch of money. I mean, it'd been nice because, social bills for the fraternity can be expensive. If Bill could have paid for all the beer, but nope, Bill didn't get that. If he did, I'd imagine he'd have been paying for it. So this is what you have. And so you kids just can't come to the trustee. I mean, think of it this way, Greg. You're a good guy here. You're the trustee. I'm the beneficiary. This trust is left for me. You're in control of it. And it says I only get it until I'm 30. If I came up to you, here I am, 22 years of age, I said, Greg, I know you're in control of these funds and I don't get them until I'm 30. But I tell you what, come on, man. Look at these two blondes I just picked up. They're twins. They're from Sweden. We're going to go around the world. I mean, literally around the world together for a year. I need $300,000. Can I have it? Right on, man. See, you don't want Greg being your trustee, right? We want Lisa as a trustee. Yeah. Yeah, well, I'd have to be in California then. So that's what you can do with the living trust. And it should own everything. When you pass away, it avoids probate. There's no attorney involved with this. When my wife's grandmother didn't have a lot, I created a trust for her. When she passed away, her aunt was in control of that trust. She wrapped it up. Didn't you say 3 months? You said 3 months, Elena? Somebody said 3 months. I said how fast you could wrap it. You said a couple of months. It was a couple of months, 3 months. Distribute out all the assets to the beneficiaries of that estate because she was in complete control. Went like clockwork. And that was even grieving time built into that. Whereas my uncle, 5 years because it was a will. So I firmly believe in everybody creating a living trust. And the other thing about it is that, when you look at dinar, and I've had this conversation with many investors, they tell me, well, Clint, I'm going to have, I assume I'm going to have X amount of $1 million after at RV, so that's when I need the living trust. I said, well, okay, that's one way to look at it, but what happens if you die before at RVs? Who's going to get those dinars? Are you just going to let your kids have it? So now here they are, 22 years of age, they're holding on to 3 million dinar apiece, and now to RVs for $4. Now they have 12 million bucks. Would you give your child $12 million at 22 years of age? Absolutely not. But you're going to give them currency that's going to RV into that, and that's okay, right? I didn't think of it that way. Well, see, that's what we do. That's what we talk about. So this is the most important piece of the puzzle because it ensures that everything is protected. And that's why we have this up here where we say living trust offers peace of mind. Once you create that, you don't need to go back to an attorney to change it. Unless your distribution changes to your children and you want to write them out of the trust or change some stuff, that's done. And you're good to go. Attorneys that create wills for people will typically create the will and say, come back and see me next year and we'll discuss whether or not you need a living trust. And they'll come back and you'll go back to them. They'll bill you for a review. Well, not yet. Come back to me next year and we'll do this again. And then finally, they'll set up a living trust for you, and you think they're going to give you a discount for what they charge you for the will when they draft the trust? Absolutely not. That's how my buddy runs his practice. He's a good guy otherwise, but I have a fundamental disagreement with when it comes to estate planning with them. That I think people should be in control of their own estates and not attorneys. So the living trust offers a peace of mind. It also reduces estate taxes. And this is a slide that I think is really important because it gives you an idea of what could happen. How much would you need to save each month to pay the estate tax on a $2 million estate in 35 years? This assumes that the estate tax is not going to be capped at the $5 million like it is right now for 2 years. And it's going to go back, which it is scheduled to go back to $1 million in 2 years from now. 2013 will be $1 million is all you can pass on. So be doing the math in your own head, how much money you're going to have, how much you can pass on free of estate tax. So in order to pay the estate tax on an estate just valued at $2 million, how much would you need to save each and every month to have enough money aside? $750 a month. Okay? If you save $750 a month at 3% annual interest, you'll have the $550,000 you'll need to pay to the federal government in order to cover just the estate tax on a $2 million estate that you pass on to your children. That's how much wealth is going to be confiscated when you pass on a $2 million estate. You know what these trusts do and these other boxes do, the LLCs? They're designed to minimize those estate taxes to the greatest extent as possible. We've had people, boxes just like this that I've created, where they've saved $450,000 on one estate, another estate was over $600,000 was put back into our clients' pockets or their beneficiaries' pockets because they had some boxes. My client was even audited. Their estate was. I tell you what, he goes, how do you justify this? I said, look at my box. This is how. IRS agent dropped the suit or dropped the audit because he read through that and said, yep, you got it. That's important. Estate taxes, it's one way in which you're going to have to up these things to pay off the debt. And so you say rest in peace. Well, you might as well put the IRS's logo on them because rest in peace really stands for this. Rip off. You built it up during your lifetime, you paid taxes on it, and then they're going to take a big chunk just to pass it on to your children. That's why we talk about when you create the LLCs, gifting the assets away now before it RVs. So you're not going to be subject to gift and estate tax. It's not included in your estate because you already gifted a chunk away to your kids. You control it, but they own it. So it's included in their estate, not in yours. That's very, very important there. So if you don't do it, I mean, it's just like this guy. Put your head in stand. Most people miss this completely. The benefit of a living trust and LLCs, how to reduce their future estate taxes. So that's what we recommend. All right. We have sign-up sheets. If you want to meet with us, the way we run these events is that we will pull you out. We go off a sign-up sheet where we have you put your name on it, and we will meet with you individually. But we meet with people during class time. So tomorrow during class time, we'll pull you out, meet with you individually. Just sign up on that list. I don't charge to meet with people. Okay, we're here to, I mean, you paid to come to the event. We're going to sit down. We're going to talk to you, talk about your individual situation. Pricing, what do we charge to set up entities? If you've already read my brochure, there's no surprises. I charge flat fees. I do not charge by the hour for my work. Never have, never will, because I work for an attorney who did. And I remember that on the end of every month, I had to lick envelopes all day long because he was sending out bills to collect. That's one reason why I don't charge by the hour, just because of the time involved in having to bill people. But you know there's more to it than that. If you're on the receiving end of a legal bill on a monthly basis, how does that make you feel, Greg? Not too good, does it? Because you can never predict what's going to come in the mail. And I have my own attorneys that I've worked with in the past on certain things, and I can tell you, I got extremely upset with this one law firm that came highly recommended. They're a big firm in Seattle. They're all nationwide. They're one of the best. But I would do this every month. Actually, I didn't. My secretary would. She'd come in. She goes, Clint, I haven't opened it yet, but you're not going to like it. I go, what do you mean? She goes, Lane Powell just sent us something. Huh? She goes, yeah, I gave it the Charmin test, and it's real squeezy. You know what that means? Multiple pieces of paper in there to justify how they're stealing money from me in a case that they're representing me in. Now, what I mean by stealing money, this is what attorneys would do. My attorney went and would have to consult with other attorneys in his firm, partners that bill at $500 an hour. So they would consult on my case without consulting me first, and all three of them would bill me while they're sitting around talking about our case and how to strategize. What do you think that is? That's stealing as far as I'm concerned. I mean, I had it out with them. I said, you cannot be doing this. You need to run this stuff by me. This is not a blank checkbook for you. This was supposed to be a simple matter, and you've taken it now and blown it up into something that's unrecognizable. But that's the way a lot of attorneys work. That's why we don't charge by the hour. We just charge a flat fee. It's $1,500 an entity. That's it. Doesn't matter what it is. Well, it does matter what it is. LLCs, trusts, things like that, they're $1,500. CRTs, they're more expensive, but that's not something we're even going to consider setting up now for you. That's something that happens afterwards. If you want to go to Nevada, it's typically $9.95 to set up all the Nevada service, where you have the mail forwarding, the physical presence, the nominee service, the bank account we get established for you. It's $995 to have it set up that way. But what's that, Greg? Okay, I know I'm getting close. But the thing is that we reduce that down for all the investors. I've already said we reduced that fee down to $695. So it's $6.95 for that service. And it's well worth it. Everybody that we've set up quite a few dinar investors with Nevada entities thus far, and they're extremely happy. When I tell you it takes about 2 weeks, it does. And we get right on it. We'll get people contacting you to set up your bank account. We will have you structured, ready to go. So when that thing RVs, you got somewhere to put that money. Entity, LLC. So say you said I wanted a LLC in Kansas. $6.95 for the Nevada component to be set up in Nevada. That's on top of the $1,500. That's on top of the $1,500. How do we, when we set up entities, I'm not a form guy. If you want form documents, you can go on my website, you can buy a kit, you can do it yourself. But I'm not a fan of that because most people I've found that try to do it themselves, and the reason I know this is because people come to me, hey Clint, I've already set something up. Really, who did it? Well, I did. Let me look at it. It's always the same. There's things that are missing along the way that leave you exposed. We take the process from A to Z. Your job is simple, and that is you give me some names for your entity, you tell me what bank you want to work with, you tell me what you have in dinar, you tell me if you want to gift it to anybody, you tell me who the members are going to be, who's going to manage it. I'll do everything else. So when you get your document, we've done all the tax filings, we've done all of the business filings with the state, we've drafted your operating agreement, whatever you told us you want in there, we've done that, we've issued out your membership interest, we've set up your bank account, you got little flags in your document. Say, sign here. That's it. If you do nothing but follow my instructions, which says sign here everywhere I've indicated, you're done. You're ready to go. Now, if you have questions, we do charge, I just said we didn't charge an hour fee, we do charge a support fee. It's quite expensive. To ask me any legal question you want at any time, to see this class again as much as you want on our website, $35 a month. I know it's a joke, but it is. We charge $35 a month. And I have some people call me up and say, Clint, I got the LLC. Just as you said, you done everything, but I got a question. What does it mean when it says sign here? You think I'm joking? I've told 1 or 2 clients in that situation, it means send it back. We need to refund you. We're not ready yet. No, I don't know. We used to have a red envelope that said do now. We used to put everything in the do now packet with the sign here, and people literally would get it. They wouldn't open it. They go, I got your LLC. I haven't done anything with it yet. Why? I don't know what to do. Well, did you see a red packet that says do now? Yeah. Am I supposed to open that? Okay, yeah. So we really try to make it as straightforward as possible. You may be overwhelmed too when you receive our documents. We do get a complaint with that. I mean, if you want to know, people say, well, where are your negatives? Is that they feel overwhelmed with the operating agreements. They're not a 6-page operating agreement. I'll tell you right now, when we draft an LLC, it's depending on what we're doing and what clauses you want in there, it's going to be between 60 to 75 pages in length. Your living trust, where it's in fine print, it's all 12-point font. Just triple spaced. No. And then the living trust is typically, depending on the situation, between 70, for the trust itself, 95 pages. But it also includes portable wills, medical powers of attorney, financial power of attorney, living wills, schedules of gifts, all these other docs that go with it. And why is it that way? Because I dealt with an individual on Wednesday who came to me or called me up and said, Clint, I want you to create a living trust. And he goes, what are you going to charge? And I tell you, when we come out to events, I give you a discount. It's $1,500. He's paying $2,000 for his. And he asked me, he goes, what do I get for $2,000? I went through all of it. He goes, great, are you going to do this? I said, yeah, I do that. And I go, well, why are you so detailed? He goes, because I have a bill right here from an attorney that wants to charge me $4,000 to do the exact same thing you're willing to do for $2,000. And he was being charged for specific clauses that we're going to put in there. He goes, are you going to put this clause in there? I said, absolutely. When we draft documents, we take the approach that you don't know what you're ever going to need. You're not supposed to. Unless you want to become an attorney and waste your time going to law school, okay, you're not going to understand this. So I take the approach that I'm going to give you more than you need. Hopefully I'm going to cover every possible contingency so in the future, if something does happen, you're covered. The classic example of this is with an S corporation. And the reason I like to bring up the S corporation because I get this comment probably 12 times a year from somebody's local attorney or CPA. They will call me up after they reviewed my trust and say, Clint, you spent no time with this client. I said, well, my files show otherwise, but I'll play along. Why? Well, you have drafted them a trust that has S corporation provisions in it. Now, had you talked to Nick and spent any time with Nick, you would know Nick does not have an S corporation. So what fictional S corporation are you trying to cover inside of this living trust? Because the one doesn't exist. So had you spent the time with Nick, you'd have figured that out. That's one way to look at it. But let me put back to you something. What happens if Nick decides to get an S corporation 10 years from now? Does Nick know that if he has a living trust and owns his S corporation, he dies and he doesn't have S corporation provisions in there to hold that under a subchapter S corporation trust, that it will invalidate his S election? Did you know that, Nick? Oh, sure I did, right? So as soon as Nick sets up his S corp, he's going to run right down to the law office and say, hey, I need the S corporation provisions in there. No, it's not going to happen that way. But if you're an attorney that's going to charge somebody every year to review their financial situation and get money out of them and add in those clauses, I guess that's the way we should go. So, Nick, you want to pay me for the rest of your life? I mean, the annuity situation here? I don't think so. So that's why we put them together. And I had some people say that they feel that there's a lot in there, more than they need. And I tell them, explain to them, there is, maybe at this point in time. But if you're like me, if you think the way I do, you will need it. And it's good to have it. Because I'd rather have it and not need it than be in the opposite situation. So you can never predict life. So that's what we do. That's what we offer. We make it extremely simple for you. You can sign up for a consultation. There will be sign-ups in the back of the room. We'll meet with you tomorrow during class. We'll pull you out. Again, this seminar is being recorded. As you can see, we have a video camera here. All this will be put in. I hope to get it up next week. It'll be on our website. You can go there and you can always refresh yourself along with all the other information that's available on our site. If you haven't been to it yet, I suggest you look at it. Sign up for our tax newsletter. Does anybody here been to our, did you get my tax newsletter I just sent out? Okay, a lot of good tax information in there that may or may not apply to you, but we send it out every month. I write a blog every week, missed this week on asset protection. You should go check it out and read it. But we try to, our goal as a firm is a little different than most firms, is we want educated clients. We want them to understand what it is we're doing for them, because then they're more apt to stick with it and use it and not get themselves into trouble. It's when you have an attorney that doesn't support the client, doesn't educate them on why they're setting it up, that you find that nothing ever gets done. So we're completely different in that manner. All right, questions? Mm-hmm. If you already have a will, the living trust replaces all of that. Yes. The will, we actually, when you draft a living trust, you also draft a pour-over will that revokes your existing will and says, hey, if I left anything outside of my big trust box, it has to be probate it, and hopefully, well, you see what that stuff that fell out, that's going to the attorneys. Okay, whatever they don't eat, put it inside of my box. All right. Any other questions? All right, so we're going to break for tonight. Tomorrow, Greg, what time are we starting? 9 o'clock. Are we having anything in the morning?
Yes, there's some bagels.
Okay, so some bagels and pastries here in the morning, coffee. We'll see you tomorrow at 9 o'clock. Sign-up sheets are in the back if you want to meet tomorrow. Tomorrow, we're going to